One addressing the investigation and prosecution of election crimes and the other describing restrictions imposed on department employees by the Hatch Act. 8 in its election crimes section, the 2016 memorandum requires consultation with PIN at various stages of all criminal matters that focus on violations of federal and state campaign finance laws, federal patronage laws and corruption of the election process. 9 However, the memorandum also states the following: simply put, politics must play no role in the decisions of federal investigators or prosecutors regarding any investigations or criminal. 6 See Loretta Lynch, Attorney General, U.S. Department of Justice, Memorandum for All Department Employees, Election Year Sensitivities, April 11, 2016, 1. 7 Lynch, Memorandum for Department Employees, 1. Eric Holder, Attorney General, U.S. Department of Justice, Memorandum for All Department Employees, Election Year Sensitivities, March 9, 2012, 1. Michael Mukasey, Attorney General, U.S. Department of Justice, Memorandum for All Department Employees, Election Year Sensitivities, March 5, 2008, 1. 8. The Hatch Act prohibits department employees from engaging in partisan political activity while on duty, in a federal facility, or using federal property, including using the Internet at work for political activities. See 5 U.S.C. 7321-7326, 2017. 9 Lynch, Memorandum for Department Employees, 1. 17 Charges. Law enforcement officers and prosecutors may never select the timing of investigative steps or criminal charges for the purpose of affecting any election, or for the purpose of giving an advantage or disadvantage to any candidate or political party. Such a purpose is inconsistent with the department's mission and with the principles of federal prosecution. Likewise, the 2016 memorandum recommends that all department employees consult with PIN whenever an employee is faced with a question regarding the timing of charges or overt investigative steps near the time of a primary or general election, without regard to the type or category of crime at issue. 10 Ray Hulser, the former section chief of PIN who currently is a dog in the criminal division, told us that this policy does not impose a mandatory consult with PIN, but rather encourages prosecutors to call if they have questions about investigative steps or criminal charges before an election. B. The unwritten 60-day rule. After the FBI released its October 28, 2016 letter to Congress informing them that the FBI had learned of the existence of additional emails and planned to take investigative steps to review them, contemporaneous emails between department personnel highlighted editorials authored by former department officials discussing a long-standing department practice of delaying overt investigative steps or disclosures that could impact an election. These former officials cited the so-called 60-day rule, under which prosecutors avoid public disclosure of investigative steps related to electoral matters or the return of indictments against a candidate for office within 60 days of a primary or general election. 11 The 60-day rule is not written or described in any department policy or regulation. Nevertheless, high-ranking department and FBI officials acknowledged the existence of a general practice that informs department decisions. Former Director Comey characterized the practice during his OIG testimony as a very important norm, which is, we avoid taking any action in the run-up to an election, if we can avoid it. Preet Bharara, the former U.S. Attorney for the Southern District of New York, told us that the department's most explicit policy is about crimes that affect the integrity of an election, such as voter fraud, but that there is generalized, unwritten guidance that prosecutors do not indict political candidates or use overt investigative methods in the weeks before an election. 10 During late 2016, department personnel also considered guidance in the federal prosecution of election offenses prohibiting overt investigative steps before an election. U.S. Department of Justice, The Federal Prosecution of Election Offenses, 7th edition, May 2007. However, this publication explicitly applies to election crimes, not to criminal investigations that involve candidates in an election. CID at 91-93. 11 See Eric Holder, James Comey is a good man, but he made a serious mistake. Wash Post, October 30, 2016, Jamie Gorelick and Larry Thompson, James Comey is damaging our democracy, Wash. Post, October 29, 2016, Jane Chong, Pre-Election Disclosures, How Does, and Should, DOJ Analyze Edge Cases, Lawfare blog, November 8, 2016, https://www.lawfareblog.com/pre-election disclosures How Does and Should DOJ Analyze Edge Cases, accessed May 8, 2018. Several department officials described a general principle of avoiding interference in elections rather than a specific time period before an election during which overt investigative steps are prohibited. Former AG Lynch told the OIG, in general, the practice has been not to take actions that might have an impact on an election, even if it's not an election case or something like that. Former DAG Yates stated, I look at it sort of differently than 60 days. To me, if it were 90 days off, and you think it has a significant chance of impacting an election, unless there's a reason you need to take that action now, you don't do it. Former Principal Associate Deputy Attorney General Matt Axelrod stated, DOJ has policies and procedures on how you're supposed to handle this. And remember, those policies and procedures apply to every election at whatever level. They apply, months before. People sometimes have a misimpression there's a magic 60-day rule or 90-day rule. There isn't. But, the closer you get to the election, the more fraught it is. Hulser told the OIG that there was a sense, there still is, that there is a rule out there, that there is some specific place where it says 60 days or 90 days back from a primary or general election, that you can't indict or do specific investigative steps. He said that there is not any such specific rule, and there never has been, but that there is a general admonition that politics should play no role in investigative decisions, and that taking investigative steps to impact an election is inconsistent with the department's mission and violates the principles of federal prosecution. Hulser said that while working on the election year sensitivities memorandum, they considered codifying the substance of the 60-day rule, but that they rejected that approach as unworkable, and instead included the general admonition described above. Citing PIN guidance, Hulser told OIG that a prosecutor should look to the needs of the case and significant investigative steps should be taken when the case is ready, not earlier or later. 12.3. Public allegations of wrongdoing against uncharged individuals and disclosure of information in a criminal investigation. The USAM instructs prosecutors that in all public filings and proceedings, federal prosecutors should remain sensitive to the privacy and reputation interests of uncharged third parties, and that there is ordinarily no legitimate governmental interest in the public allegation of wrongdoing by an uncharged party. USAM 927.760. Accordingly, even where prosecutors have concluded that an uncharged individual committed a crime, department policies generally prohibit the naming of unindicted individuals, as well as co-conspirators, because their privacy and reputational interests merit significant consideration and protection. See USAM 911.130, 9-16.500, 9-27.760. 12. Hulser produced an excerpt of a publication, written by a former deputy chief of PIN, discussing the issues involved in choosing the timing for charging a public corruption case. U.S. Department of Justice, Prosecution of Public Corruption Cases, February 1988, 214-15. 19. Department regulations governing interactions with the media recognize that the availability to news media of information in criminal and civil cases is a matter which has become increasingly a subject of concern in the administration of justice. 28 CFR 50.2, A. 1. Addressing this concern, the FBI issued a Media Relations Policy Guide for FBI personnel. The FBI Media Relations Policy Guide recognizes that the regulations found at 28 CFR 50.2 lay out specific and controlling guidelines addressing the release of information to the media from department authorities as well as from subordinate law enforcement components, including the FBI. ID, see also 28 CFR 0.1. The FBI Media Relations Policy Guide also recognizes that the USAM offers further specific guidance consistent with federal regulations in its Media Policy section governing the release of information, by all components, FBI, and DOJ divisions, and personnel of the Department of Justice. USAM 1-7.001. The Department's policy and regulations forbid the confirmation or denial and any discussion of active investigations, except in limited, specified circumstances. USAM 1-7.530. Taken together, these documents offer an understanding of department operations related to the media, particularly publicity around FBI investigations. A FBI Media Relations Policy. In October 2015, the FBI issued the version of its media relations at FBI headquarters, HQ, and in field offices policy guide, FBI Media Policy Guide. Pertinent to this review. Point 13. The FBI Media Policy Guide recognizes that the FBI Office of Public Affairs, FBI OPA, works to enhance the public's trust and confidence in the FBI by releasing and promoting information about the FBI's responsibilities, operations, accomplishments, policies, and values. The FBI Media Policy Guide confirms that FBI OPA operations are governed by DOJ OPA's instructions, located at Title 28 Code of Federal Regulations, CFR 50.2, and by the United States Attorney's Manual USAM, Title 1-7.000, Media Relations. As such, where the guidance in the FBI Media Policy Guide conflicts with the USAM or 28 CFR 50.2, the USAM and Code of Federal Regulations control FBI media practices. In its provisions governing disclosure of information to the media from FBI headquarters in Washington, the FBI Media Policy Guide states the FBI Director, FBI Deputy Director, DD, Associate Deputy Director, AD, Assistant Director for FBI OPA, and FBI OPA personnel designated by the OPA Assistant Director are authorized to speak to the media. However, ALL releases of information by any FBI personnel authorized to speak to the media must conform with all applicable laws and regulations, as well as policies issued by DOJ, which includes specific reference to the USAM, among other department legal authorities. The FBI Media Policy Guide itself constrains authorized disclosures, explaining Disclosures 13. The October 2015 FBI Media Policy Guide is available online in the FBI Records Vault. See FBI Office of Public Affairs, Media Relations at FBIC and in Field Offices Policy Guide, October 13, 2015, https://go.usa.gov/xqnxq, accessed May 7, 2018. On November 14, 2017, the FBI released a significantly revised guidance for media relations entitled Public Affairs Policy Guide, Media Relations, External Communications, and Personal Use of Social Media. 20. Must not prejudice an adjudicative proceeding and must not address an ongoing investigation except in specified circumstances. Point 14. The FBI Media Policy Guide offers limited justifications to release information regarding an ongoing investigation, specifying the need to assure the public that an investigation is in progress, to protect the public interest, welfare, or safety, or to solicit information from the public that might be relevant to an investigation. Any such release requires prior approval of FBIC entities, and the careful supervision of OPA. The FBI Media Policy Guide specifies that when releasing information to the media via a press conference, FBI OPA personnel must request approval in advance from DOJ OPA for any case or investigation that may result in an indictment. Further, FBI personnel must coordinate with DOJ OPA on any materials, quotes, or information to be released in the press conference. B28 CFR 50.2. In all criminal matters, federal regulations bar department personnel from furnishing any statement or information, if such a statement or information may reasonably be expected to influence the outcome of a future trial. 28 CFR 50.2, b. 2. The regulation also provides that where information relating to the circumstances of an investigation would be highly prejudicial or where the release thereof would serve no law enforcement function, such information should not be made public. 28 CFR 50.2, b. 3. The regulations permit, subject to limitations, some facts to be released publicly, including a defendant's name, age, and similar background information, the substance of the charges at issue, specified details regarding an investigation, and the circumstances surrounding an arrest. See 28 CFR 50.2, b. 3. But while permitting this limited release, the regulation specifies that the department personnel making the public disclosures should include only incontrovertible, factual matters, and should not include subjective observations. ID. These strict limitations shall apply to the release of information to news media from the time a person is the subject of a criminal investigation until any proceeding resulting from such an investigation has been terminated by trial or otherwise. 28 CFR 50.2, b. 1. A department official explained to the OIG that otherwise included criminal actions ended when the department declines to prosecute. The regulations do provide for exceptions, acknowledging situations in which the regulations limit the release of information which would not be prejudicial under the particular circumstances. 28 CFR 50.2, b. 9. When a department official believes that in the interest of the fair administration of justice and the law enforcement process information beyond these guidelines should be released, in a particular case, he shall request the permission of the Attorney General or the Deputy Attorney General to do so. ID 14. When FBI officials make a public comment, the FBI Office of General Counsel must advise FBI OPA on the potential impact of public comment on proposed and pending litigation. 21 CUSAM Media Relations Guidance. The Attorney General's central role to information disclosures to the media is also recognized in the USAM's Media Relations Policy. 15 CUSAM 1-7.210. The USAM makes clear that final responsibility for all matters involving the news media and the department is vested in the Director of the Office of Public Affairs, OPA, and, without exception, the Attorney General is to be kept fully informed of appropriate matters at all times. USAM 1-7.210. The USAM's Media Relations section offers several provisions governing how information disclosure to the media may permissibly take place. Overall, the USAM 1-701(e) requires any public communication by any investigative agency about pending matters or investigations that may result in a case, or about pending cases or final dispositions, must be approved by the appropriate Assistant Attorney General, the United States Attorney, or other designate responsible for the case. Reinforcing a general principle of non-disclosure, the USAM declares at no time shall any component or personnel of the Department of Justice furnish any statement or information that he or she knows or reasonably should know will have a substantial likelihood of materially prejudicing an adjudicative proceeding. USAM 1-7.500. In keeping with that principle, USAM 1-7.530 instructs department personnel that, except in unusual circumstances, they shall not respond to questions about the existence of an ongoing investigation or comment on its nature or progress, including such things as the issuance or serving of a subpoena, prior to the public filing of the document. Those unusual circumstances where comment may be appropriate included matters that have already received substantial publicity, or about which the community needs to be reassured that the appropriate law enforcement agency is investigating the incident, or where release of information is necessary to protect the public interest, safety, or welfare. USAM 1-7.530. But in any such circumstances, the involved investigative agency will consult and obtain approval from the department division handling the matter prior to disseminating any information to the media. ID USAM 1-7.401 addresses specifically press conferences, emphasizing a preference for written press releases as the usual method to release public information, by investigative agencies. While permissible, press conferences should be held only for the most significant and newsworthy actions, or if a particularly important deterrent or law enforcement purpose would be served. Prudence and caution should be exercised in the conduct of any press conference. USAM 1 to 7.401. Repeatedly the USAM states that before holding a 15 the department significantly revised the USAM media relations provisions in November 2017, retitling them under Confidentiality and Media Contacts Policy. This report primarily addresses the USAM media relations provisions in effect at the time of the events within the scope of this review. We consider the revised USAM provisions related to the media in Chapter 6 of this report. 22 Press conference. Prior coordination with OPA is required for information of national significance. USAM 1-7.330, b. 1-7.401, b. For release of information to Congress. The provision of information from the Department and the FBI to Congress is governed by Department Policy Guidance, the USAM, and FBI Rules. 16a USAM Congressional Relations Guidance under the USAM Title 1 to 8.000, and consistent with 28 CFR 0.27, communications between Congress and the Department are the responsibility of the Assistant Attorney General, Office of Legislative Affairs, OLA. Point 17 as written, the USAM 1 to 8.000 generally addresses personnel within the staff of the various United States Attorney's offices. However, USAM 1 to 8.000 explicitly applies to department components, and several provisions of the USAM guidance regarding the department's congressional relations bind all department personnel. 18 One such provision is USAM 1 to 8.030 requiring coordination of a department response when Congress seeks information that is not public. USAM 1 to 8.030 states ALL congressional requests for information, other than public information, meetings of any type, or assistance must immediately be referred to the OLA. The USAM lists the following examples of congressional requests requiring referral to OLA: requests for non-public documents or information, discussion of or requests for briefings on cases, and suggestions or comments on case disposition or other treatment. USAM 1 to 8.030. These standards apply in both open and closed cases, and the USAM highlights a specific bar on providing information on 1. Pending investigations, 3. Matters that involve grand jury, tax, or other restricted information, 4. Matters that would reveal sensitive investigative techniques, deliberative processes, the reasoning behind the exercise. 16 We note that the policies and rules described herein do not restrict lawful whistleblowing, protections for which were recognized by Attorney General Sessions in a recent memorandum reiterating the Department's commitment to protecting the rights of whistleblowers, i.e., those employees or applicants who have made a lawfully protected disclosure to Congress. Jefferson B. Sessions, Attorney General, U.S. Department of Justice, Memorandum for all heads of department components, Communications with Congress, May 2, 2018, 2. 17 According to the Code of Federal Regulations, the following described matters are assigned to, and shall be conducted, handled, or supervised by, the Assistant Attorney General, Office of Legislative and Intergovernmental Affairs, a. Maintaining liaison between the Department and the Congress. 28 CFR 0.27. 18 While the AAG of OLA is responsible for communications between Congress and the Department under the authority of the Attorney General per the USAM, that authority does not override statutory reporting requirements to Congress, such as those required for the OIG found at 5 U.S.C. App 4, A, 5. 23 Of prosecutorial discretion, or the identity of individuals who may have been investigated but not indicted. 19 IDB FBI Guidance on Information Sharing with Congress. The FBI's status as the primary investigative agency of the federal government makes its sharing of information with Congress of special concern. Relevant guidance is provided in the Attorney General's Guidelines for Domestic FBI Operations, AGDOM, and the FBI's Domestic Investigations and Operations Guide, DIOG. The AgDOM directs that the FBI may disseminate information obtained or produced through its domestic investigations to congressional committees as authorized by the Department of Justice Office of Legislative Affairs 20 AgDOM 6.b.1, c. This direction is reinforced in the DIOG's section on the retention and sharing of information, which states that the FBI may disseminate information obtained or produced through activities under the AgDOM to Congress or to congressional committees in coordination with the FBI Office of Congressional Affairs, OCA, and the DOJ Office of Legislative Affairs. DIOG 14.3.1, d. Notably, both the AgDOM and DIOG anticipate circumstances requiring departure from their rules. DIOG 2.6 to 2.7. The DIOG spells out how such departures may occur, usually involving high-level FBI approval, coordination with the FBI Office of General Counsel, and notice and/or approval at the highest levels of the Department of Justice. IDC current department policy on communication of investigative information to Congress. While the USAM, AgDOM, and DIOG lay out the consistent institutional relationships in the department and its components for congressional information flow, the department also uses policy memoranda and other communications to provide guidance on how communication should be handled with Congress in sensitive, investigation-related circumstances. Among these are two memoranda governing department communications with Congress and a letter addressing the principles of department communications with Congress on ongoing investigations. 19 On its face, this portion of USAM 1 to 8.030 addresses U.S. Attorneys' offices specifically. But the provision thereafter offers broader guidance that ALL requests for these types of information should be referred to OLA. USAM 1 to 8.030. Moreover, a department official with long-term experience in OLA explained that he viewed the entirety of the USAM guidance on congressional relations as helping to understand the playing field on which we operate in terms of a sensitivity of congressional contacts. 20 The FBI is required to coordinate with OLA before sending formal communications to Congress regarding substantive matters that impact the department. According to a department official with long-term experience in OLA, the FBI can sometimes speak to Congress more informally by email or phone about certain types of matters like procedural matters, without first obtaining OLA approval. 24.1. Policy Memoranda on Department Communications with Congress. On May 11, 2009, then Attorney General Holder issued a policy memorandum for all department components, including the FBI, entitled Communications with Congress and the White House, May 2009 memo. In addressing pending criminal investigations and cases, the May 2009 memo explained that the heads of investigative agencies, tasked with the primary duty of initiating and supervising cases, must be insulated from influences that should not affect decisions in particular criminal cases. The May 2009 memo continues that for communications with Congress, consistent with policies, laws, regulations, or professional ethical obligations, and consistent with the need to avoid publicity that may undermine a particular investigation, congressional inquiries related to pending criminal investigations and cases should be directed to the Attorney General or DAG. 21 On August 17, 2009, then Attorney General Holder issued an updated memo, August 2009 memo, entitled Communications with Congress. The August 2009 memo clarified that all inquiries from congressional officials should be directed to DOJ/OLA. The August 2009 memo also spelled out that all communications between the department and Congress should be managed by OLA to ensure that relevant department interests and other executive branch interests are protected. Opponents should not communicate with members, committees, or congressional staff without advance coordination with OLA. The August 2009 memo concluded with direction for component heads to contact DOJ/OLA for any questions on the policy. 22.2. The Linder letter. In a January 2000 letter from the department's AAG for OLA to then Congressman John Linder, Linder letter, the department described in detail the principles that guide OLA and the department in their decision to disclose or withhold information from Congress. The letter remains a reference guide for OLA. The Linder Letter lays out governing principles to foster improved communications and sensitivity between the executive and legislative branches regarding our respective institutional needs and interests. After discussing the general tension between the interests of the two branches, the Linder Letter 21, the May 2009 memo, exempts congressional hearing communications and communications internal to an investigation from this requirement. The August 2009 memo does not include any exemption for congressional hearing communications. 22 On January 29 and May 2, 2018, Attorney General Sessions released memoranda also entitled Communications with Congress that reiterated an expanded direction to department and component personnel regarding coordination with OLA, consistent with past policy and practice. Among other changes, the May 2018 memorandum states communications between the Department and Congress will be managed or coordinated by OLA to ensure that relevant department and executive branch interests are fully protected. In addition, the May 2018 memorandum states that OLA will review prior to transmittal all department written communications to Congress, including letters and any other materials intended for submission or presentation on Capitol Hill. 25 Examines the inherent threat to the integrity of the department's law enforcement and litigation functions that comes from congressional inquiries during pending investigations. The letter noted that this concern was especially significant with respect to ongoing law enforcement investigations. It then described the department's long-standing policy, dating back to the beginning of the 20th century, to decline to provide congressional committees with access to open law enforcement files. One risk, according to the letter, is the possible public perception that such congressional inquiries amount to pressure resulting in undue political and congressional influence over law enforcement and litigation decisions. Another risk is the severe damage to the reputations of those mentioned in disclosure of information on open matters, even though the case might ultimately not warrant prosecution or other legal action. Finally, even when an investigation results in a declination, the Linder Letter explains that the disclosure of information contained in such a declination memorandum would implicate significant individual privacy interests as well. Such information often contains unflattering personal information as well as assessments of witness credibility and legal positions. The disclosure of the contents of these documents could be devastating to the individuals they discuss. Special Counsel Regulations. Since the 1999 lapse of the Independent Counsel Reauthorization Act, department regulations govern the process of appointing a special counsel. 28 U.S.C. 591 to 599, 64 Federal Reg. 37038, 1999. According to 28 CFR 600.1, the Attorney General, or Acting Attorney General, may appoint a special counsel for the criminal investigation of a person or matter when it would be in the public interest and there exists a department conflict of interest or other extraordinary circumstance. The regulations provide that the Attorney General need not appoint a special counsel immediately when a possible conflict emerges. Instead, the Attorney General may authorize further investigation or mitigation efforts, such as recusal. See 28 CFR 600.2. The special counsel must come from outside the government. 23 C 28 CFR 600.3. The Attorney General sets the criminal jurisdiction of the special counsel through a specific factual statement of the matter to be investigated, though the Attorney General may authorize the 23 in 2003, then Deputy Attorney General James Comey, who was the acting Attorney General after the recusal of then Attorney General John Ashcroft, appointed a U.S. Attorney as special counsel in a letter citing 28 U.S.C. 509, 510, 515, which describe the delegation authority of the Attorney General's office. See United States v. Scooter Libby, 429 F. Sup. 27, 40, DDC 2006. This method of appointing a special counsel did not rely on department regulations, eliminating restrictions on who may be appointed special counsel and removing guidance setting the Attorney General's supervisory role over the office. See 28 CFR 600.2, 600.7. 26 additional areas of investigation. 2428 CFR 600.3 to 600.4. Day to day, the Special Counsel is not subject to department supervision, but the Attorney General maintains the ability to review and overrule Special Counsel decisions in certain circumstances. 28 CFR 600.7. 6 criminal statutes relevant to the mid-year investigation. 4 statutes governing the handling and retention of classified information are relevant to the mid-year investigation: 18 U.S.C. 793, D, 793, E, 793, F, and 1924.25 Section 793, F, 1, which prohibits the grossly negligent removal of national defense information, became a central focus of the investigation and of subsequent prosecutive decisions. In addition to the mishandling and retention statutes, prosecutors also considered whether former Secretary Clinton or others violated 18 U.S.C. 2071, a criminal statute prohibiting the willful concealment, removal, or destruction of federal records, in connection with the deletion of emails. We discuss the Department's analysis of these statutes in Chapter 7. A. Mishandling and retention of classified information. 1. 18 U.S.C. 793, D, and E, Sections 793, D, and E, are felony statutes that apply to the willful mishandling and retention of classified information. Section 793, D, governs the mishandling of classified documents or information by individuals who are authorized to possess it, that is, who have the appropriate security clearance and require access to the specific classified information to perform or assist in a lawful and authorized governmental function. Need to know. Point 26 Section 793, D, provides, whoever, lawfully having possession of, access to, control over, or being entrusted with any document, writing, code book, signal book, sketch, photograph, photographic negative, blueprint, plan, map, model, instrument, appliance, or note relating to the national defense, or information relating to the national defense which information the possessor has reason to believe could be used to the injury of the United States or to the advantage of any foreign nation, willfully communicates, delivers, transmits or causes to be communicated, delivered, or transmitted or attempts to communicate, deliver, transmit or cause to be communicated, delivered or transmitted the same to any person not entitled to receive it, or willfully retains the 24. A special counsel's jurisdiction also covers federal crimes committed in the course of, and with the intent to interfere with, the special counsel's investigation, such as perjury, obstruction of justice, destruction of evidence, and intimidation of witnesses. 28 CFR 600.4. 25 Under the USAM, the Department's National Security Division, NSD, must expressly approve any prosecution involving these statutory provisions. See USAM 9 to 90.020. 26 C Exec. Order 13526 4.1, A, 1, 3, 6.1, dd, December 29, 2009. See also United States v. Truong Din Hung, 629 F.2 D 908, 919 N.10, 4th Sir 1980. 27 Same and fails to deliver it on demand to the officer or employee of the United States entitled to receive it, is subject to a criminal fine or imprisonment. Thus, to prove a violation of Section 793, D, the government must establish the following: the individual lawfully had possession of documents or information relating to the national defense, if information, he or she had reason to believe that the information could be used to the injury of the United States or to the advantage of a foreign nation, and the individual willfully communicated, delivered, or transmitted the document or information to a person not entitled to receive it, or willfully retained the document or information and failed to deliver it to the officer or employee of the United States entitled to receive it. Section 793, E, addresses the possession and transmission of classified information by persons who are not authorized to possess it, either because they lacked the requisite security clearance and need to know, or because they exceeded the scope of their authorization by removing classified materials from a secure facility. Point 27. Apart from this distinction, Sections 793 D and 793 E are substantially identical. Information relating to the national defense. Both 793 D and 793 E apply to individuals who possess documents or information relating to the national defense. This term is not defined in the statute. Courts have not limited this phrase to any specific subject matter, but the Fourth Circuit has held that the government must establish first that the information is closely held by the government, and second, that its disclosure would be potentially damaging to the United States or useful to an enemy of the United States. United States v. Rosen, 445 F sub 2D 602, 618, 620-21, ed. Virginia 2006, Rosen I, citing Gorin v. United States, 312 U.S. 19, 1941, United States v. Morrison, 844 F.2d 1057, 1073, 4th Sir 1988, United States v. Truong, 629 F.2d 908, 918-19, 4th Sir 1980, United States v. Heine, 151 F.2d 813, 817, 2d Sir 1945. The classification level of information may be highly probative of whether the information at issue is information relating to the national defense and whether the person to whom they disclosed the information was entitled to receive 27C, e.g., United States v. Hitzelberger, 991 F sub 2d 101, 104, DDC 2013, Navy linguist who printed and removed secret documents indicted under 793, e. United States v. Chatton, 33 MJ 802, 803, 1991, Navy seaman who stuffed classified document down his pants and walked out of a secure facility charged under 793, e. 28 at. 28. However, classification level does not conclusively establish that a document or information is information relating to the national defense. In United States v. Rosen, 599 F sub 2d 690, 694-95, ed. Virginia 2009, Rosen 2, the court stated that the term information relating to the national defense is not synonymous with classified information. While the classification level of information may serve as evidence that the government intended that it be closely held, the defendant can rebut the conclusion by showing that the government in fact failed to hold it closely. The court also stated that the classification level could not be introduced to show that unauthorized disclosure of the information might potentially damage the United States or aid an enemy of the United States. Point 29. Willfulness. Sections 793, D, and E, both require that the prohibited act be done willfully. Courts have interpreted willfully to mean an act done intentionally and purposely and with the intent to do something the law forbids, that is, with the bad purpose to disobey or to disregard the law. 30. In Rosen I, the court held that to prove that the defendants willfully committed the conduct prohibited under sections 793, D, and E, the government is required to prove beyond a reasonable doubt, that the defendants knew the information was indeed information relating to the national defense, i.e., that the information was closely held by the United States and that disclosure of this information might potentially harm the United States, and that the persons to whom the defendants communicated the information were not entitled under the classification regulations to receive the information. Further, the government must prove beyond a reasonable doubt that the defendants communicated the information they had received from their government sources with a bad purpose, either to disobey or to disregard the law. It follows, therefore, that if the defendants, or 28 Rosen I, 445 F sub 2d at 623, see also Hitzelberger, 991 F sub 2d at 106, document marked secret was information relating to the national defense because the classification level indicated that it would cause serious damage to the security of the United States if lost, and defendant's training placed him on notice that the government considers information in classified documents important to national security. United States v. Kiriaka, 2012 WL 326-3854, at *6, ed. Virginia 2012, unreported decision, rejecting defendant's argument that 793(d) is unconstitutionally vague because courts have relied on the classified status of information to determine whether it is closely held by the government and harmful to the United States. United States v. Kim, 808 F. Sup. 2d 44, 53, DDC 2011. Defendant's vagueness challenge is particularly unpersuasive in light of the fact that he is charged with disclosing the contents of an intelligence report, which was marked top secret/sensitive compartmented information. 29 Several weeks before trial was scheduled to begin, prosecutors moved to dismiss the indictment based on the unexpectedly higher evidentiary threshold required to prevail at trial. See Motion to Dismiss, United States v. Rosen, CRIM No. 1:05 CR 225, ed. Virginia filed May 1, 2009. 30 Bryan v. United States, 524 U.S. 184, 190, 1998, cited in Hitzelberger, 991 F. Sup. 2d at 107-08, see also Morrison, 844 F.2d at 1071, United States v. Truong, 629 F.2d 908, 918-19, 4th Sir 1980. 29 Either of them were truly unaware that the information they are alleged to have received and disclosed was classified, or if they were truly ignorant of the classification scheme governing who is entitled to receive the information, they cannot be held to have violated the statute. 31 Additional burden of proof for disclosures of intangible information. Courts have held that sections 793, d, and e contain a heightened or additional mens rea requirement where the transmission of intangible information, as contrasted with the retention or transmission of classified documents, is involved. 32 In addition to showing that an individual acted willfully, the government must prove beyond a reasonable doubt that he or she possessed reason to believe that the information could be used to the injury of the United States or to the advantage of a foreign nation. 33 Vagueness challenges the term information relating to the national defense in sections 793, d, and e, repeatedly. Has been challenged as unconstitutionally vague. Courts have rejected such challenges because the statute requires the government to prove that an individual willfully committed the prohibited conduct, a requirement that eliminates any genuine risk of holding a person criminally responsible for conduct which he could not reasonably understand to be proscribed. 34 2. 18 U.S.C. 793, f. Section 793, f. 1, known as the gross negligence provision, became a central focus in the controversy over the decision not to recommend prosecution of former Secretary Clinton or her senior aides, and former Director Comey's public statement on July 5, 2016. Below we discuss the statutory requirements under Section 793, f. The mid-year prosecutor's interpretation of Section 793, f. 1, and previous cases in which prosecution was declined under the gross negligence provision. A statutory requirements Section 793, f. provides as follows: 31 Rosen I, 445 F. Sup. 2d at 625, internal citation omitted. 32 C. Hitzelberger, 991 F. Sup. 2d at 105, Drake, 818 F. Sup. 2d 909, 916-17, DMD. See also United States v. Leung, No. 03 CR 434, CD Cal July 14, 2003. 33 C. Rosen I, 445 F. Sup. 2d at 643, see also Memorandum Opinion, United States v. Sterling, No. 1:10 CR 00485 LHB, filed June 28, 2011. Government asserted that it must prove that the defendant acted willfully and had reason to believe the information would harm the United States where he is alleged to have disclosed classified information. 34 ID at 625, Morrison, 844 F.2D at 1073, Truong, 629 F.2D at 918-19, 4th Sir 1980, see also Gorin v. United States, 312 U.S. 1941, holding that information connected with or relating to the national defense used in the predecessor to a related Espionage Act statute was not unconstitutionally vague because the statute included a scienter requirement. 30 Whoever, being entrusted with or having lawful possession or control of any document, writing, code book, signal book, sketch, photograph, photographic negative, blueprint, plan, map, model, instrument, appliance, note, or information, relating to the national defense, 1. Through gross negligence permits the same to be removed from its proper place of custody or delivered to anyone in violation of his trust, or to be lost, stolen, abstracted, or destroyed, or, 2. Having knowledge that the same has been illegally removed from its proper place of custody or delivered to anyone in violation of its trust, or lost, or stolen, abstracted, or destroyed, and fails to make prompt report of such loss, theft, abstraction, or destruction to his superior officer, is subject to a criminal fine or imprisonment. Section 793, F. 1. Addresses the removal, delivery, loss, theft, abstraction, or destruction of any document or information relating to the national defense through gross negligence, while Section 793, F. 2. Penalizes the failure to report the removal, loss, theft, abstraction, or destruction of any document or information relating to the national defense, if an individual has knowledge that it has been removed from its proper place of custody. Section 793, F, like Sections 793, D, and E, requires that the information in question be information relating to the national defense. In United States v. Didion, 584 F.2d 36, 39, 4th Sir 1978, the Fourth Circuit upheld jury instructions in a Section 793, F. 2, case that required the government to prove that disclosure of information in the document would be potentially damaging to the national defense, or that information in the document disclosed might be useful to an enemy of the United States. B. Prosecutor's interpretation of the gross negligence provision in Section 793, F. 1, Section 793, F. 1, does not define what constitutes gross negligence, nor have any federal court decisions interpreted this specific provision of the statute. However, the prosecutors analyzed the legislative history of Section 793, F. 1, and identified statements made during the 1917 congressional debate indicating that the state of mind required for a violation of Section 793, F. 1, is so gross as to almost suggest deliberate intention, criminally reckless, or something that falls just a little short of being willful. The prosecutors cited a statement by Congressman Andrew Volstead during the 1917 debate about the predecessor to Section 793, F. 1. I want to call attention to the fact that the information that is covered by this section may be, and probably would be, of the very highest importance to the government. It is not an unusual provision at all. It occurs in a great many criminal statutes. Men are convicted for gross negligence, but it has to be so gross as almost to suggest deliberate intention before a jury will convict. For instance, a person is killed by a man running an automobile recklessly on a crowded street. He may, and under the laws of most states would be, adjudged guilty 31 of manslaughter, and can be sent to state prison. We have, as I have already stated, a number of statutes of that kind. This provision is not revolutionary. It is the ordinary practice to apply such statutes to cases where lack of care occasions the death or serious injury of persons. This section should be, and probably would be, applied only in those cases where something of real consequence ought to be guarded with extreme care and caution. 35 Given the absence of a definition of gross negligence in Section 793, F. The prosecutors researched state manslaughter statutes in effect at the time of the 1917 congressional debate, and determined that gross negligence was interpreted in that context to require wantonness or recklessness that was equivalent to criminal intent. However, the prosecutors also identified contemporaneous state court decisions interpreting other criminal statutes using gross negligence to require proof that ranged from something more than civil negligence to willful, intentional conduct. The mid-year prosecutors did not find any court cases addressing the state of mind required for a violation of Section 793, f(1). However, the prosecutors analyzed United States v. Didion, 584 F.2 D 36, 39, 4th Sir 1978, a Fourth Circuit decision interpreting Section 793, f(2). This case involved a civilian employee who completed a military vulnerability analysis and marked it secret, then took a copy of it home to proofread. While at home, his cousin secretly photographed part of the analysis with a camera provided by the Soviet Union. When the defendant later learned that his cousin had taken these photos, he accepted $1,000 as a payment for remaining silent rather than reporting that the information had been compromised. Upholding the statute against a challenge that it was unconstitutionally vague, the court held that Section 793, f(2), requires the government to prove that the defendant knew that the document had been illegally abstracted, and that this knowledge requirement was sufficient to save the statute from vagueness. In addition, the mid-year prosecutors reviewed previous prosecutions under Section 793, f(1), in federal or military courts and concluded that these cases involved either a defendant who knowingly removed classified information from a secure facility, or inadvertently removed classified information from a secure facility and, upon learning of its removal, failed to report its loss, theft, abstraction, or destruction. 36 The prosecutors concluded that based on case law in the 3565 Cong Rec. H. 1762-63, Daily ed. May 3, 1917. 36C Indictment, United States v. Smith, No. 03 CR 429, CD Cal filed February 24, 2004, see also United States v. Courpelet, No. ACM 35571, 2005 WL 486145, AFCTCRIM App February 10, 2005, defendant removed 4 classified photographs and took them home, United States v. Roller, 37 MJ 1093, 1993, defendant inadvertently placed 2 classified documents in his gym bag and took them home, and left the documents in his garage when he later discovered them, United States v. Chatton, 33 MJ 802, 1991, defendant stuffed classified documents down his pants and took them home, United States v. Gaffney, 17 MJ 565. 1983, defendant was supposed to destroy classified material but instead took it home and put it in a neighborhood dumpster, United States v. Gonzalez, 12 MJ 747, 1981, defendant intermingled 2 classified messages with personal mail. He was 32 departments prior interpretation of the statute, charging a violation of Section 793, f, likely required evidence that the individuals who sent emails containing classified information knowingly included the classified information or transferred classified information onto unclassified systems, Section 793, f, 1, or learned that classified information had been transferred to unclassified systems and failed to report it, Section 793, f, 2. Thus, the mid-year prosecutors interpreted the gross negligence provision of Section 793, f, 1, to require proof that an individual acted with knowledge that the information in question was classified. 37 As noted above, Sections 793, d, and e, have survived constitutional vagueness challenges because of the existence of a scienter requirement in the form of the requirement to prove willfulness. Such a challenge has not yet been raised in a Section 793, f, 1, gross negligence case. The mid-year prosecutors stated, The government would likely face a colorable constitutional challenge to the statute if it prosecuted an individual for committing gross negligence who was both unaware he had removed classified information at the time of the removal and never became aware he had done so. Moreover, in bringing a vagueness challenge, defense counsel would also likely point to the significant disagreement as to the meaning of gross negligence. See previous Section 793, f. 1, declinations. The mid-year prosecutors also reviewed at least 2 previous investigations where prosecution was declined under the gross negligence provision in Section 793, f. 1. The mid-year prosecutors told us that these declinations informed their understanding of the department's historical approach to Section 793, f. 1. We discuss these previous declinations below. Gonzales declination decision. One of these previous cases involved an OIG investigation into the mishandling of documents containing highly classified, compartmented information about a national security agency, NSA, surveillance program by former White House counsel and Attorney General Alberto Gonzales. In 2004, while Gonzales carrying to a friend in Alaska, then put the message in a desk drawer in the friend's room and forgot them. Cf. United States v. Oxford, 44 MJ 337, 1996, defendant removed classified messages from a sensitive compartmented information facility, SCIF, in Japan with the intention of passing them along to individuals who were not entitled to receive them, although the opinion states the defendant was charged under 793(e), prosecutors found documents referencing charges filed under Section 793, f. 1, based on the same facts. United States v. McGinnis, 33 MJ 781, 1991, defendant took home numerous classified items from previous assignments and was charged under Section 793(e), but a Section 793, f. 1, conviction was set aside for statute of limitation reasons. 37 Proof of such knowledge would also be necessary to establish a violation of Sections 793, d, or e, which required proof of willfulness. Accordingly, as detailed below and in subsequent chapters, the investigative team focused significant attention on determining whether Clinton, her senior aides, and senders of emails that contained classified information had actual knowledge of the classified status of the information. 33 was the White House counsel. He took handwritten notes memorializing a meeting about the legality of the NSA program. The notes included operational details about the program, including its compartmented code word. Although Gonzales did not mark the notes as classified, he said that he used 2 envelopes to double-wrap the notes and may have written an abbreviation for the code word on the inner envelope. On the outer envelope, Gonzales said that he wrote AGI's only top secret. He stored these notes in a safe in the West Wing of the White House and said that he took them with him when he became the Attorney General in February 2005. Gonzales said that he did not recall where he stored the notes after removing them from the White House, but that he may have taken them home. Gonzales also stored the notes and several other documents containing TS//Psi classification markings in a safe in the Attorney General's office that was not approved to hold such materials. The OIG referred investigative findings to NSD for a prosecutive decision. According to information reviewed by the OIG, on August 19, 2008, NSD analyzed Gonzales' handling of the notes under the gross negligence provision in Section 793, f. 1. NSD concluded that prosecutors likely could show that the documents were removed from their proper place of custody, but that the question was whether that removal constituted gross negligence. After discussing the legislative history of Section 793, f. 1, NSD stated that the government likely would have to prove that Gonzales' conduct was criminally reckless to establish that he acted with gross negligence under Section 793, f. 1. NSD concluded that Gonzales' inability to recall precisely where he stored the notes detracted from prosecutors' ability to show a state of mind approaching deliberate intention to remove classified documents from a secure location. A USA declination decision. The mid-year prosecutors also reviewed another 2008 case in which prosecution was declined under Section 793, f. 1. This case involved an AUSA who sent numerous boxes of documents to his personal residence in the United States following an overseas tour as a legal attaché. According to the prosecutor's analysis, the boxes contained a large number of documents that were classified at the secret and confidential levels. Many of these documents were organized haphazardly or were improperly marked. The AUSA testified that he did not purposely ship classified documents to his house, but acknowledged that it was highly likely that the documents he shipped included some classified materials. Interpreting Section 793, F.1, NSD stated that prosecutors likely would be required to prove that the AUSA's conduct was criminally reckless. NSD identified factors suggesting that the AUSA's conduct did not rise to the level of gross negligence, including that he testified that he did not purposely ship classified documents to his house, and thus he did not deliberately intend to remove the classified documents from a secure location. In addition, the documents were not separated into classified and unclassified categories, and they did not contain proper classification markings in that the first few pages of certain documents were not marked but later pages in the same document contained classification 34 markings. Based on these and other factors, NSD concluded that prosecution was not warranted. 318 U.S.C. 1924 Section 1924 is a misdemeanor statute that prohibits the knowing removal of documents or materials containing classified information without authority and with the intent to retain such documents or materials at an unauthorized location. To establish a violation of this statute, the government must show that an individual knowingly removed classified materials without authority and intended to store these materials at an unauthorized location. To remove without authority means that the classified materials were removed from the controlling agency's premises without permission. 38 Although no reported cases interpret this provision, the mid-year prosecutors concluded that Section 1924 requires the government to show beyond a reasonable doubt that the defendant had knowledge that the location where he or she intended to store classified material was an unauthorized or unlawful place to retain it, citing the legislative history, the Petraeus case we describe below, and other previous prosecutions under this provision. High-profile cases considered by the mid-year prosecutors and by FBI leadership involving plea agreements under Section 1924 include former Central Intelligence Agency, CIA, Director David Petraeus, former National Security Advisor Samuel Sandy Berger, and former CIA Director John Deutsch. In each of these cases, the defendants knew the information at issue was classified or took actions reflecting knowledge that their handling or storage of it was improper. Petraeus, a retired U.S. Army general, served as the commander of the International Security Assistance Force in Afghanistan from July 2010 to July 2011, and as the director of the CIA from September 2011 to November 2012. While in Afghanistan, Petraeus kept notes in black notebooks that included information about the identities of covert officers, war strategy, intelligence capabilities and mechanisms, diplomatic discussions, quotes and deliberative discussions from high-level National Security Council meetings, and discussions with the President. Petraeus retained these notebooks when he returned from Afghanistan and later shared them with his biographer, Paula Broadwell, admitting to her in a recorded conversation that the notebooks were highly classified and contained code word stuff. He also stored them in an unlocked desk drawer in his home office. During a subsequent investigation into his mishandling and retention of classified information, Petraeus falsely told the FBI that he never provided or facilitated the provision of classified information to Broadwell. In March 2015, Petraeus pled guilty to one count under 18 U.S.C. 1924, and was sentenced to 2 years of probation, a $25 special assessment, and a $100,000 fine. 3938 See Exec. Order 13526, 4.1, d. 39C Plea Agreement and Factual Basis, United States v. Petraeus, CRIM No. 3:15 CR 47. WDNC filed March 3, 2015, Information, Petraeus, 2015 WL 188-4065, WDNC filed March 3, 2015, charging Petraeus with knowingly removing classified documents without authority, and with the 35 Sandy Berger, the National Security Advisor under former President Bill Clinton, visited the National Archives and Records Administration to review documents for production to the 9/11 Commission. During his visits, Berger concealed and removed documents by folding the documents in his clothes, walking out of the National Archives building, and placing them under a nearby construction trailer for later retrieval. 40 Berger removed a total of 5 copies of classified documents, stored them in his office, and later destroyed 3 of them by cutting them into small pieces and discarding them. All of these documents were marked classified. Berger also created and removed handwritten notes of classified material that he had reviewed, and was aware that he removed these notes from the National Archives without authorization. Berger pled guilty to a criminal information charging 1 count of 18 U.S.C. 1924.41. He was sentenced to 2 years of probation, a $56,905.52 fine, a $25 special assessment, and 100 hours of community service, and was precluded from accessing classified information for 5 years. Former CIA Director John Deutsch was investigated for using unclassified, Internet-connected computer systems to create and process classified documents and storing classified memory cards in his personal residence. During an investigation by the CIA Inspector General, CIA IG, investigators recovered files from a computer at Deutsch's residence that were labeled as unclassified but contained words indicating that the information was secret or top-secret codeword, or was otherwise highly sensitive. For example, recovered documents included reports on covert operations, communications intelligence, memoranda to then-President Bill Clinton, and classified CIA budget information. The CIA IG report states that Deutsch told investigators that he fell into the habit of using the unclassified system in an inappropriate fashion, and admitted that he had intentionally created highly sensitive documents on unclassified computers. In addition, witnesses testified that Deutsch was considered to be an expert or fairly advanced computer user. Following a criminal investigation, Deutsch agreed to plead guilty to 1 count under 18 U.S.C. 1924, but was pardoned by President Clinton on January 19, 2001, before the plea was consummated. Examples of conduct prosecuted under Section 1924 include a former government employee who stored boxes of marked classified documents in his personal residence, a contractor who downloaded classified information from a secure network to a thumb drive, transferred the information to an unclassified computer, and shared it with others, and a government employee who concealed and removed highly classified documents from a sensitive compartmented intent to retain such documents and materials at unauthorized locations, aware that these locations were unauthorized for the storage and retention of such classified documents. 40 See National Archives, Notable Thefts from the National Archives, at https://www.archives.gov/research/recover/notable-thefts.html, accessed March 1, 2018. 41 See Factual Basis for Plea, United States v. Berger, CRIM No. 1:05 MJ00175 DDC filed April 1, 2005. 36 Information Facility, SCIF, where he worked and stored the documents in his vehicle and house. B. 18 U.S.C. 2071, A, Section 2071, A, is a felony statute criminalizing the concealment, removal, or mutilation of government records filed in any public office. To establish a violation of this provision, the government must prove the following beyond a reasonable doubt: an individual concealed, removed, or destroyed a record, or attempted to do so, or took and carried away a record with the intent to do so, the record was filed or deposited in a public office of the United States, and the individual acted willfully and unlawfully. The purpose of this statute is to prohibit conduct that deprives the government of the use of its documents, such as by removing and altering or destroying them. 42 The mid-year prosecutors concluded that every prosecution under Section 2071 has involved the removal or destruction of documents that had already been filed or deposited in a public office of the United States, i.e., physical removal of a document. In addition, to fulfill the requirement that the individual acted willfully and unlawfully. Section 2071 requires the government to show that he or she acted intentionally, with knowledge that he or she was breaching the statute. 4342 See United States v. Hitzelberger, 991 F sub 2d 108, 124, DDC 2014, see United States v. Rossner, 352 F. sub 915, 919-20, SDNY 1972, United States v. North, 716 F. sub 644, 647, DDC 1989, 43 See United States v. Moylan, 417 F.2d 1002, 1004, 4th. Sir 1969. 37 Chapter 3, Overview of the Mid-Year Investigation. In this chapter, we provide an overview of the mid-year investigation. More specifically, we describe the referral and opening of the investigation, the staffing of the investigation by the Department and the FBI, and the investigative strategy. Referral and opening of the investigation. A background. 1. Clinton's use of private email servers. Hillary Clinton served as Secretary of State from January 21, 2009, until February 1, 2013. During that time, she used private email servers hosting the @clintonemail.com domain to conduct official State Department business. 44 According to FBI documents, former Secretary Clinton and her husband, former President Bill Clinton, had a private email server in their house in Chappaqua, NY, beginning in approximately 2008, before Clinton's tenure as Secretary of State, for use by former President Clinton's staff. Former Secretary Clinton told the FBI that, in or around January 2009, she directed aides to create the clintonemail.com account, and that this was done as a matter of convenience. According to the FBI letterhead memorandum, LHM, summarizing the mid-year investigation, Clinton used her clintonemail.com account and personal mobile devices linked to that account for both personal and official business throughout her tenure as Secretary of State. The LHM states that Clinton decided to use a personal device to avoid carrying multiple devices. Clinton never personally used an official State Department email account or State Department-issued handheld device during her tenure, although there were official State Department email accounts from which emails were sent on her behalf. 2. Production of emails from the private email servers to the State Department and subsequent deletion of emails by Clinton's staff. On September 11 and 12, 2012, terrorists attacked the U.S. Temporary Mission Facility and a Central Intelligence Agency, CIA, annex in Benghazi, Libya, killing 4 Americans. 45 On May 8, 2014, the U.S. House Select Committee on Benghazi, House Benghazi Committee, was established to investigate the Benghazi attack and, thereafter, sought documents from the State Department as part of its 44. As described in Chapter 5, the FBI discovered 3 servers that for different periods stored work-related emails sent or received by Clinton during her tenure as Secretary of State. 45 See U.S. Senate Select Committee on Intelligence, Review of the Terrorist Attacks on U.S. Facilities in Benghazi, Libya, September 11 to 12, 2012, 113th Cong, 2D Ses, 2014, S. Report 113 to 134, https://www.intelligence.senate.gov/sites/default/files/publications/113134.pdf, accessed May 7, 2018. 38 Investigation. In the summer of 2014, State Department officials contacted Cheryl Mills, who had served as former Secretary Clinton's Chief of Staff and Counselor, concerning the State Department's inability to locate Clinton's and other former secretaries' emails to respond to congressional requests. Mills later told the FBI that she suggested that the State Department officials search State Department systems for Clinton's clintonemail.com email address. In addition, Mills told the FBI that State Department officials requested that she produce former Secretary Clinton's emails and advised her that it was Clinton's or Mills's obligation to filter out personal emails from what was provided to State. Former Secretary Clinton asked Mills and Clinton's personal attorney, David Kendall, to oversee the process of providing her emails to the State Department. In late summer 2014, Mills contacted Paul Cometa, an employee of the company that administered Clinton's private server at the time, and requested that he transfer copies of Clinton's emails onto Mills's laptop and a laptop belonging to Heather Samuelson, a lawyer who had served in the State Department as Secretary Clinton's White House liaison. Mills, Samuelson, and Kendall then developed a methodology for Samuelson to cull former Secretary Clinton's work-related emails from her personal emails, to produce her work-related emails to the State Department. In October and November 2014, the State Department sent letters to 4 former Secretaries of State, including Clinton, requesting that they make available copies of any federal records in their possession, such as emails sent or received on a personal email account while serving as Secretary of State. 46 In December 2014, former Secretary Clinton produced to the State Department from her personal email account approximately 55,000 hard copy pages, representing approximately 30,000 emails that she believed related to official business. 47 After receiving these documents, the State Department, in addition to responding to the House Benghazi Committee's document request, reviewed Clinton's emails for potential public release in response to Freedom of Information Act, FOIA, requests. As described in Chapter 5, Mills, Samuelson, and Cometa told the FBI that in late 2014 or early 2015 Mills and Samuelson asked Cometa to remove former Secretary Clinton's emails from their laptops. Cometa then used the commercial software BleachBit to permanently remove or wipe former Secretary Clinton's emails from Mills's and Samuelson's laptops. 48 Mills told the FBI that at some point between November 2014 and January 2015, Clinton decided she no longer wished to retain on her server emails that were older than 60 days. And Mills 46 See U.S. Department of State Office of the Inspector General, State IG, Office of the Secretary, Evaluation of Email Records Management and Cybersecurity Requirements, ESP 16-03, May 2016, https://oig.state.gov/system/files/esp 16-03.pdf, accessed May 7, 2018, 3. 47 See State IG, Office of the Secretary, 4. 48 According to documents we reviewed, BleachBit is a freely available software that advertises the ability to shred files. Shredding is designed to prevent recovery of a file by overwriting the content. 39 Instructed Cometa to change Clinton's email retention policy accordingly. Cometa, however, failed to do so until late March 2015. On March 3, 2015, the House Benghazi Committee sent preservation orders requiring former Secretary Clinton to preserve emails on her servers. 49 As described in more detail in Chapter 5, Cometa told the FBI that later in March 2015 he realized that he had neglected to make the change to former Secretary Clinton's email retention policy earlier that year, had an oh shit moment, and, without consulting Mills, used BleachBit to permanently remove Clinton's emails from her server. These included emails that had been transferred from a prior server. According to FBI documents, former Secretary Clinton's attorneys advised Cometa about the Congressional Preservation Order before he made the deletions. As a result of Cometa's actions, 31,830 emails that former Secretary Clinton's attorneys had deemed personal in nature were deleted from 3 locations on which they had previously been stored: Mills's and Samuelson's laptops and the Clinton server. State Department Inspector General and ICIG review of Clinton's emails and subsequent 811 referral. On March 12, 2015, 3 members of Congress requested that the State Department Inspector General, State IG, conduct a review regarding State Department employees' use of personal email for official purposes. The members of Congress requested that the state IG coordinate with the Office of the Intelligence Community Inspector General, ICIG, to determine whether classified information was transmitted or received by State Department employees over personal systems. Following this request, the ICIG reviewed 296 of the 30,490 emails that former Secretary Clinton's attorneys had provided to the State Department and determined that at least 2 of these emails contained classified information. The 296 emails, including the 2 determined to contain classified information, had already been publicly released by State Department FOIA officials. In a June 24, 2015 letter, Kendall told the state IG and the ICIG that a copy of the 30,490 emails provided by former Secretary Clinton to the State Department was stored on a thumb drive in his law office and that her personal server was in the custody of the company Platte River Networks, PRN. Based on this information, the ICIG concluded that the thumb drive and personal server contain classified information and are not currently in the government's possession. On July 6, 2015, the ICIG made a referral to the FBI pursuant to Section 811(c) of the Intelligence Authorization Act of Fiscal Year 1995, 811 referral. This provision requires executive branch departments and agencies to advise the FBI immediately of any information, regardless of its origin, which indicates that 49C U.S. House of Representatives, Select Committee on the Events Surrounding the 2012 Terrorist Attack in Benghazi, Final Report of the Select Committee on the Events Surrounding the 2012 Terrorist Attack in Benghazi, 114th CONG, 2D Sess, 2016. H. Report 114 to 848, https://www.congress.gov/congressional report/114th Congress/House report/848/1, accessed May 7, 2018. 40 Classified information is being, or may have been, disclosed in an unauthorized manner to a foreign power or an agent of a foreign power, and is typically used to refer to the FBI loss or unauthorized disclosure of classified information. The ICIG referred the matter to the FBI for any action you deem appropriate. See FBI's decision to open a criminal investigation on July 10, 2015. The FBI Counterintelligence Division opened a criminal investigation in response to the 811 referral from the ICIG. Although only a small percentage of 811 referrals result in criminal investigations, witnesses told the OIG that a criminal investigation was necessary to determine the extent of classified information on former Secretary Clinton's private server, who was responsible for introducing the information into an unclassified system, and why it was placed there. The FBI gave the investigation the code name Mid-Year Exam, choosing it from a list of randomly generated names. The FBI predicated the opening of the investigation on the possible compromise of highly sensitive classified secure compartmented information, SCI. One of the mid-year case agents told us that the mid-year investigative team was focused at the outset on the potential unauthorized storage of classified information on an unauthorized system and then where it might have gotten sick from there. A department prosecutor assigned to the investigation similarly described the scope of the investigation as related to the email systems used by Secretary Clinton, and whether on her private email server there are individuals who improperly retained or transmitted classified information. The FBI designated the mid-year investigation as a sensitive investigative matter, SIM. According to the DIOG, a SIM includes an investigative matter involving the activities of a domestic public official or domestic political candidate, involving corruption or a threat to the national security, as well as any other matter which, in the judgment of the official authorizing an assessment, should be brought to the attention of FBI headquarters and other DOJ officials. FBI witnesses told us that the SIM designation is typically given to investigations involving sensitive categories of persons such as attorneys, judges, clergy, journalists, and politicians, and that SIM investigations are overseen more closely by FBI management and the FBI Office of General Counsel than other investigations. The mid-year investigation was opened with an unknown subject, unsub, and at no time during the investigation was any individual identified by the FBI as a subject or target of the investigation, including former Secretary Clinton. FBI witnesses told us that the unsub designation is common and means that the FBI has not identified a specific target or subject at the outset of an investigation. According to FBI witnesses, this allowed the FBI to expand the focus of the investigation based on the evidence without being locked into a particular subject. With respect to the mid-year investigation, witnesses told the OIG that the FBI did not identify anyone as a subject or target during the investigation because it was unclear how the classified material had been introduced to the server and who was responsible for improperly placing it there. 41 Despite the unsub designation, witnesses told us that a primary focus of the mid-year investigation was on former Secretary Clinton's intent in setting up and using her private email server. An FBI OGC attorney assigned to the mid-year team, FBI Attorney 1, told the OIG, "We certainly started looking more closely at the secretary because they were her emails." Randall Coleman, the former assistant director of the Counterintelligence Division, stated, "I don't know why that was the case, why it was unsub. I'm really shocked that it would have stayed that way because certainly the investigation started really kind of getting more focused." In his OIG interview, Comey described former Secretary Clinton as the subject of the mid-year investigation and stated that he was unaware that the investigation had an unsub designation. Similarly, in his book, Comey referred to former Secretary Clinton as the subject of the mid-year investigation, stating that one question the investigation sought to answer was what Clinton was thinking when she mishandled that classified information 50D initial briefing for the department on July 23, 2015. Coleman and then Deputy Director Mark As met with Deputy Attorney General, DAG, Sally Yates and Principal Associate Deputy Attorney General, PDAG, Matt Axelrod to brief them on the opening of the mid-year investigation. According to Coleman, he and Giuliano told Yates and Axelrod why the mid-year investigation was opened and laid out their vision of how the investigation would be conducted, including that the FBI planned to run the investigation out of headquarters. Yates recalled being briefed by Giuliano and Coleman at the beginning of the mid-year investigation, but said that she did not recall having concerns about the information they presented at the meeting or remembering anything significant about it. Axelrod told the OIG that Giuliano and Coleman showed them a copy of the 811 referral that the FBI had received, and either showed them or told them about some of the emails that had been identified as potentially classified. Axelrod stated that, "My recollection is that the way they explained it was that review of the certain emails contained on the personal server that Secretary Clinton had been using showed that some of those emails contained classified information. And that they, one of the things that was sort of standard practice when there was classified information on non-classified systems was that a review needed to be done to sort of contain I think the word they use in the intelligence community is a spill. The spill of classified information out into sort of a non-classified arena. And so that they needed to, this was a referral so that the Bureau could help contain the spill and identify if there was classified information on non-classified systems so that that classified information could be contained and either, U50 James Comey, A Higher Loyalty, Truth, Lies, and Leadership at 162, Amy Einhorn, ed., 1st ed. 2018. 42 No, destroyed or returned to proper information handling mechanisms. Asked whether he considered the mid-year investigation to be criminal as of the date of this initial briefing, Axelrod replied, "Not in my view." According to Axelrod, it was some time before at least I understood that it had morphed into a criminal investigation. The prosecutors and career department staff assigned to the mid-year investigation told us that they considered it a criminal investigation from early on. Deputy Assistant Attorney General, DOG, George Toscas, who was the most senior career department official involved in the daily supervision of the investigation, told us that he approached it as a criminal investigation from the beginning of NSD's involvement. Prosecutors 1 and 2, both of whom were assigned to the investigation by late July 2015, understood that it was a criminal investigation from very early in the investigation. Prosecutor 1 told us, "I mean, pretty quickly this seemed like a a criminal investigation. It looked, and it smelled like a criminal investigation to me. 2. Staffing the mid-year investigation. FBI staffing the mid-year investigation was conducted by the FBI's Counterintelligence Division. For the first few weeks, the investigation was staffed by FBI headquarters personnel and temporary duty assignment, TDY, FBI agents. Thereafter, FBI management decided to run the investigation as a special out of FBI headquarters. This meant that the investigation was staffed by counterintelligence agents and analysts from the FBI Washington Field Office, WFO, who were temporarily located to headquarters and received support from headquarters personnel. FBI management selected WFO personnel based on WFO's geographic proximity to headquarters and its experience conducting sensitive counterintelligence investigations. FBI witnesses told us that previous sensitive investigations also had been run as specials, and that this allowed FBI senior executives to exercise tighter control over the investigation. There were approximately 15 agents, analysts, computer specialists, and forensic accountants assigned on a full-time basis to the mid-year team, as well as other FBI staff who provided periodic support. 4 WFO agents served as the mid-year case agents and reported to a WFO Supervisory Special Agent, SSA. Several FBI witnesses described the SSA as an experienced and aggressive agent, and the SSA told us that he selected the 4 strongest agents from his WFO squad to be on the mid-year team. 43 The SSA reported to Peter Strzok, who was then an Assistant Special Agent in Charge, ASAC, at WFO. 51 Comey and Coleman told us that Strzok was selected to lead the mid-year investigative team because he was one of the most experienced and highly regarded counterintelligence investigators within the FBI. There were also several analysts on the mid-year team. Some analysts assigned to mid-year were on the review team, which reviewed and analyzed former Secretary Clinton's emails. These analysts reported to a supervisory intelligence analyst, who in turn reported to the lead analyst. FBI witnesses, including Coleman, told us that the lead analyst was highly regarded within the FBI and very experienced in counterintelligence investigations. Other analysts were on the investigative team, which assisted the agents with interview preparation and performed other investigative tasks. These analysts reported to the SSA and Strzok, in addition to reporting directly to the lead analyst. Several analysts were on both the review and investigative teams. Until approximately the end of 2015, the lead analyst and Strzok both reported to a section chief in the Counterintelligence Division, who in turn reported to Coleman for purposes of the mid-year investigation. 52 The remainder of the reporting chain was as follows: Coleman to John Giacalone, who was Executive Assistant Director, EAD, of the National Security Branch, Giacalone to D.D. Giuliano, and D.D. Giuliano to Director Comey. During the course of the investigation, some FBI officials involved with the mid-year investigation retired or changed positions. In late 2015, Coleman became the EAD of the FBI Criminal, Cyber, Response, and Services Branch and was no longer involved in the mid-year investigation. At the same time, E.W. Bill Priestap replaced Coleman as AD of the Counterintelligence Division. EAD Giacalone and D.D. Giuliano retired from the FBI in early 2016 and were replaced by Michael Steinbach and Andrew McCabe, respectively. In addition, Lisa Page, who was special counsel to McCabe, became involved in the mid-year investigation after McCabe became the deputy director in February 2016. Page told the OIG that part of her function was to serve as a liaison between the mid-year team and McCabe. Page acknowledged that her role upset senior FBI officials, but told the OIG that McCabe relied on her to ensure that he had the information he needed to make decisions, without it being filtered through multiple layers of management. Several witnesses told the OIG that Page circumvented the official chain of command, and that Strzok communicated important mid-year case information to her, and thus to McCabe, without Priestap's or Steinbach's knowledge. McCabe said that he was aware of complaints about Page, and that he valued her ability to spot issues and bring them to his attention when others did not do so. 51 Strazek was promoted to a section chief in the Counterintelligence Division in February 2016, and to Deputy Assistant Director, DAD, in the fall of 2016. 52 A Deputy Assistant Director in the Counterintelligence Division was between the section chief and Coleman in the reporting chain but had limited involvement in the mid-year investigation. 44 The FBI Office of General Counsel, OGC, assigned FBI Attorney 1, who was a supervisory attorney in the National Security and Cyber Law Branch, NSCLB, to provide legal support to the mid-year team. A second, more junior attorney, FBI Attorney 2, also was assigned to the mid-year team. FBI Attorney 1 reported to Deputy General Counsel Tricia Anderson, who in turn reported to then General Counsel James Baker. 53 Figure 3.1 describes the FBI chain of command for the mid-year investigation. This figure does not include intervening supervisors who had limited involvement in the investigation. 53 Anderson now is the Principal Deputy General Counsel. Figure 3.1, FBI Chain of Command for the Mid-Year Investigation. Special Counsel Lisa Page, February 2016 March 20, 18, INSBEAD FBI Director James Corney I Deputy Director Andrew McCabe, February 2016 to March 2018, Mark G. Yuliano, November 2013 to January 2016, Michael Steinbach, February 2016 to February 2017, Office of General Counsel John Giacalone, July 2015 to February 2016, T. Jim. Baker. NSCLB Chief of Staff Jim Rybicki AD Counterintelligence Division, CD, EW Bill Priestap, January 20, 16 Present, Randy Coleman, May 20, 14 December 2015, Deputy General Counsel Tricia Anderson Agent Lead Pete Strazek F Supervisory Special Agent T Agents Lead Analyst. Analysts 45. NSCLB Attorneys FBI Attorney 1 FBI Attorney 2 46B Department Staffing within the department. The mid-year investigation was primarily handled by the Counterintelligence and Export Control Section, CES, of the National Security Division, NSD, with support from 2 prosecutors in the United States Attorney's Office for the Eastern District of Virginia, EDVA. All of the prosecutors assigned to the mid-year team had significant experience handling national security investigations or white-collar criminal cases. The lead prosecutor, Prosecutor 1, was a supervisory attorney in CES. Prosecutor 1 told us that he selected the best non-supervisory line attorney within CES, Prosecutor 2, to handle the mid-year investigation with him. The 2 CES prosecutors reported directly to the chief of CES, David Loffman, who in turn reported to Dog George Toscas. Toscas was the highest-level career department employee involved in the mid-year investigation, and the prosecutors and supervisors below him who were involved in the mid-year investigation were also career employees. As described in more detail below, department officials above Toscas, including then Assistant Attorney General, AAG, John Carlin, Axelrod, Yates, and Lynch, received briefings about the mid-year investigation but were not involved in its day-to-day management. In August 2015, EDVA was brought into the mid-year investigation. EDVA assigned 2 supervisory attorneys to work with the CES prosecutors, Prosecutor 3 and Prosecutor 4. The role of the EDVA prosecutors initially was to facilitate the issuance of legal process, including grand jury subpoenas, search warrants, and 2703(d) orders. However, the NSD prosecutors told the OIG that ultimately they consulted and worked closely with the EDVA prosecutors on many issues and decisions throughout the course of the mid-year investigation. Prosecutor 3 similarly told us that as the investigation progressed, he and Prosecutor 4 were considered equal partners with the NSD prosecutors. EDVA senior leadership, including then U.S. Attorney Dana Boent, received briefings on the mid-year investigation from the EDVA prosecutors and were informed of significant developments, but they were not involved in investigative decisions. Axelrod told the OIG that he recalled that he spoke to Boent early in the mid-year investigation and let them know that this was NSD's investigation. Axelrod stated, "So many times when you have a U.S. Attorney's Office and a main justice component, things have to go up two chains and that's cumbersome. In an investigation like this we figured it was easier just to have everything centralized in NSD. There's a reason why NSD has the ticket on, all these matters, right? They're the subject matter experts. Axelrod explained that NSD has primary responsibility for counterterrorism and counterintelligence cases not only because it has subject matter expertise in those areas, but also because those cases are nationwide. He stated that there are certain areas of law where it is important to ensure nationwide consistency in how 47 the law is applied, because if one district does something really different than another district it can have very bad ramifications or consequences. As noted previously, the USAM requires NSD to expressly approve in advance charges involving certain national security statutes, including those that were considered in this investigation. Prosecutor 2 stated that NSD's typical role varies from case to case, and depends on the resources and experience of the specific U.S. Attorney's Office. This prosecutor told the OIG that NSD typically drives counterintelligence cases, but that its role runs the gamut from taking the lead on cases to playing a supporting role. Prosecutor 2 stated that EDVA has been more willing to allow NSD attorneys to play an active role in charged cases and is very open to NSD's partnership and support. Prosecutor 3 similarly told the OIG that EDVA's supporting role in the mid-year investigation was unusual, but he attributed this to logistics. This prosecutor stated, "Prosecutors 1 and 2 were right across the street from FBI headquarters. It was pretty work-intensive, more so for them because they would have to go over there at the drop of a hat for meetings. We were always kept in the loop of what was going on. But the FBI kept a pretty tight hold of the classified documents." Prosecutor 3 also said that running the case out of NSD, supervised by Toscas, allowed the department to keep one central location of control by a career person over the investigation. Several witnesses told us that the FBI was frustrated at the perceived slow pace of bringing a U.S. Attorney's Office into the mid-year investigation. However, Toscas told us that it is not unusual for a U.S. Attorney's Office not to be involved in the beginning of an investigation, and that it took some time to determine the proper venue and select the most appropriate U.S. Attorney's Office. Prosecutor 1 told us that although the U.S. Attorney's Office for the District of Columbia also was considered, EDVA was selected in part based on the good historical working relationship between NSD and EDVA. Boent told the OIG that he expressed concerns that EDVA was not the appropriate district given that former Secretary Clinton lived in New York. He said that they potentially could establish venue through an email server or victim agency server located in EDVA, but that it would be unusual to select venue to prosecute a high-profile public figure on that basis. Boent said that while no one explained why the department chose EDVA, he assumed that it was because we move quicker and do things a lot quicker than some districts can. 3. Role of senior FBI and department leadership in the investigation. FBI leadership. The mid-year investigation was closely supervised by FBI leadership from the outset. Comey told the OIG that he received frequent briefings on the mid-year investigation, 48, and then once it got underway, either in July or maybe in August 2015, I told them I wanted to be briefed on it on a much more frequent basis than I would normally on a case because I was keen to make sure that they had the resources they need and that there was that I could both support them if they needed additional things and protect them in the event anybody outside of the investigative team tried to monkey with them in any way or exert any pressure on them or anything like that. Because I could see immediately how significant the matter was. So I think they got into a rhythm of briefing me maybe every couple of weeks. Comey said that briefings took place roughly every 2 to 3 weeks at the beginning of the investigation, and occurred on a weekly basis as the investigation progressed. Comey said that the mid-year briefings typically were attended by a core team of senior officials, the Deputy Director, Giuliano, then McCabe, Comey's Chief of Staff, James Rybicki, FBI OGC personnel including Baker, Anderson, and FBI Attorney 1, the EAD of the National Security Branch, Giacalone, then Steinbach, the AD of the Counterintelligence Division, Coleman, then Priestap, Deputy Director McCabe's counsel, Lisa Page, beginning in February 2016, and Strizek and the lead analyst. Other FBI officials periodically attended these briefings, including then Associate Deputy Director, AD, David Bodick after his appointment in April 2016, but witnesses told us that briefings were carefully controlled and limited to a select group of senior FBI managers. Comey said that the mid-year team typically produced a bi-weekly or weekly written summary of their progress in the investigation, and that briefings generally focused on what the team had completed and what needed to be done. Comey stated, He Wei attended to break down as the lead analyst would talk about exploitation of media and sorting through emails and things. And Pete Strizek would focus on investigative steps, interviews, things like that. Comey told the OIG, IT would typically be here in the director's conference room at the table and they would give me a progress report on where they were and I would typically ask the questions that were rooted in my interest in it to begin with, which is, do you have the resources you need? Any problems that I can help you with? I just felt the need to stay close to it. 49 As described in more detail in Chapter 6, the same officials were involved in discussions about whether to do a public statement announcing the closing of the mid-year investigation. Comey characterized these discussions as great family conversations, stating that he was a great believer in oppositional argument and encouraged people to bring up different points of view. In addition to the mid-year specific meetings, Comey and the deputy director, first Giuliano, then McCabe, had daily morning and late afternoon meetings about significant developments or issues that were impacting the FBI. The mid-year investigation was sometimes discussed immediately following these meetings in sidebar meetings involving a smaller group of participants due to the sensitivity of the investigation. 54 As the result of these frequent briefings, Comey and McCabe knew about and were involved in significant investigative decisions. McCabe stated, Comey relied on me for kind of my advice and recommendation on those decisions. But he was very involved in the decisions on mid-year. Not decisions like what time is the interview with John Jones going to take place tomorrow, but, we think we should serve a subpoena on so and so for these records, and the Department of Justice is saying no, we want to try to work it out with a letter. And so, as that conflict was brewing, he would learn about it and weigh in on it and not necessarily decide it. But he was up to speed on all of the kind of significant things that were happening in the case. McCabe told the OIG that although Strizek and Priestap made the day-to-day investigative decisions, he and Comey were informed about any problems that arose during the investigation, as well as any significant information that the team discovered. As described in more detail in Chapter 5, our review found examples where Comey or McCabe approved or directed specific investigation decisions. These included directing the mid-year agents to deliver a preamble at the first interview of Cheryl Mills about the need to answer questions about the process used to cull former Secretary Clinton's personal and work-related emails, without informing the prosecutors, authorizing Baker to contact Beth Wilkinson, counsel to Mills and Samuelson, again without telling the prosecutors, approving the consent and immunity agreements used to obtain the Mills and Samuelson laptops, and not prohibiting Mills and Samuelson from attending the interview of former Secretary Clinton as her counsel. 54 other senior FBI officials involved in the mid-year investigation received additional briefings as needed. The Deputy Director, EAD, and AD met on a daily basis regarding significant matters affecting the Counterintelligence Division, and these meetings at times included significant developments in the mid-year investigation. McCabe said he was briefed when issues arose. In addition, the lead analyst and Strizek briefed Giacalone on the mid-year investigation on a weekly basis. 50B Department leadership. Unlike the FBI's senior leadership, senior department officials played a more limited role in the mid-year investigation. Although Lynch, Yates, Axelrod, and Carlin described making a conscious decision to allow the career staff to handle the mid-year investigation with minimal involvement by political appointees, they also told us that their involvement was consistent with their normal role in criminal investigations. Lynch told the OIG that she received limited briefings on the mid-year investigation. She explained that the mid-year investigation was not discussed at her morning meetings or staff meetings because it was a sensitive matter and involved potentially classified information. Lynch said that she had a monthly meeting with NSD, and that although the mid-year investigation was too sensitive to discuss during that meeting, afterward the meeting would skinny down to discuss sensitive cases among a smaller group of people that included Yates, Axelrod, Carlin, Toscas, and sometimes members of her staff. She said that the cases discussed among this smaller group included not only the mid-year investigation, but also other sensitive counterterrorism and classified cases. Lynch said that she understood that there were political sensitivities inherent in the mid-year investigation, and she wanted to protect the mid-year team from perceived pressure from department leadership. She stated, "Because we knew that it was going to be scrutinized, we wanted to make sure that not only was the team supported, but they also were insulated from a lot of people talking about it and just discussing it in general throughout the office. And so, my view was that unless you need me for something, I don't want to be on top of the team for this. They should work as they always work. They should know that they have whatever they need to have, whatever resources they need to get. But the front office is not, breathing down their neck on this." Asked whether there was ever a conscious decision by the political appointees to step back and allow the career employees to handle the investigation, Lynch replied, "Certainly it was my view, and I can't recall having discussions about that. But that was how I viewed the setup, was that we wanted to make sure that this was always handled by the career people, and that essentially even though they would need input, and certainly toward the end of anything you'd have to make certain decisions. But not to have, at least certainly from, the 5th floor level where I was, not to have that kind of input early on. Although I typically wouldn't have had input, in the inner workings of an investigation." 51 Lynch said that Toscas was the most senior career department official involved in making decisions about the mid-year investigation, and that she had faith and confidence in his ability to handle the case. Lynch explained that she was not involved in the day-to-day investigative decisions about how to staff the investigation, what witnesses to interview, or any of the other things that she used to do as a line assistant U.S. attorney, AUSA. Nor did she intervene in conflicts between the prosecutors and agents. She told the OIG that this was not unique to the mid-year investigation but rather represented her standard practice, stating, "My view is that, whoever is leading the team needs to deal with that initially because they've got to keep working with each other. And based on my experience as an AUSA, if you can resolve it at that level first, you will have a team that is more solid and can work together more easily. If not, then I think the next level supervisor has got to be involved in that. My view is that the chain of command is set up is there for that reason. But I wouldn't, if someone said to me the agents want to interview this person, and the prosecutors don't, my first question before I got involved would be to say what do the supervisors think? Because if I as AG, or even as U.S. Attorney immediately step in and make that decision, then what I've done is I may have solved a problem, but I've cut the knees off of every supervisor in between me and them. And that creates bigger problems down the road." Lynch said her view was that problems or conflicts should not be elevated to the Attorney General unless the parties had exhausted all other remedies. Yates and Axelrod. Yates told the OIG that although department leadership understood the significance of the mid-year investigation, they agreed that it should be handled like any other case. She said that the role of department leadership in the mid-year investigation represented their normal approach to criminal investigations, stating, "Okay, we got the sensitivity of this matter obviously even from the beginning. And I remember we wanted to make certain that NSD had all the resources that they needed, that they were on top of it. That we stayed briefed on what was going on, but from the very beginning it was important to us for this to be handled like any other case would be handled. That we wanted to make sure that the line prosecutors and lawyers who were doing this didn't feel like they had the leadership office breathing down their neck because that's going to put a layer of pressure on them that is not appropriate, we felt like here. So it was important to us for NSD to be handling the day-to-day aspects of this. But at the same time we wanted to make sure that they were getting what they needed. And that we were staying apprised of significant developments in it. 52. Not only doing it the right way but making sure that we did this, that it had the appearance of doing it the right way too. And public confidence was going to be important. We knew that from the very beginning. And that we wanted to make sure that we had a process in place that was going to be the right process. And that would be for NSD to handle the day-to-day aspects of it. And so we had that conversation. You know, the dog's office is really sort of more the operational one between the two leadership offices. And so I certainly had conversations with the AG about how we set this up and we're running it. But again, there was no real dispute with anybody about this. This seemed like the natural and right way to do things. Asked whether her role in the mid-year investigation differed at all from her usual process, Yates replied, "Every other case is not on the radar screen of the DAG, obviously. But this was a significant matter for the department that was one of those small handful of cases that how you do it can be defining for the Department of Justice. And we were very aware of that from the very beginning. So when I say we were handling it like any other case, what I mean is that we wanted to ensure that the factors that went into a decision about how we should proceed in that matter and how, the kind of latitude that the line people were handling had to do it in that matter, that should be done like any other case. Nobody should get any special treatment. Nobody should be treated more harshly, because of who they were. That's what I mean, it should be like any other case. But we weren't stupid. I mean, we recognized that the profile and import of this matter was such that we needed to make sure that things were done correctly. Yates explained that the DAG typically gets involved in an investigation from a decision-making standpoint if there is disagreement between one of the department's litigating components and another government agency, or between a department component and a U.S. Attorney's office, or if there is real uncertainty about whether to take a potential investigative step. She stated, "Normally the dog's office is not running an investigation and we weren't running this one." Yates told the OIG that she received more frequent updates on the mid-year investigation than she did on other cases, attributing this to the profile and time sensitivity of the investigation. Yates told the OIG that it was hard to generalize how frequently she received updates, but that she had regular meetings with NSD every other week. Although the mid-year investigation was not discussed with the larger group present during these meetings, afterward they would skinny down to a smaller group to discuss sensitive matters, including the mid-year investigation. This smaller group included Carlin, Toscas, and Mary McCord, who was at the time the principal dog in NSD. Yates said that she also participated in Lynch's regular meetings with NSD, which would similarly skinny down at the end. 53. The NSD and EDVA prosecutors told the OIG that they were concerned at various points during the mid-year investigation that there was a disparity between the involvement of department and FBI leadership in discussions about investigative steps. For example, while McCabe, the second-in-command at the FBI, attended meetings at which the mid-year agents and prosecutors debated whether and how to obtain the Mills and Samuelson laptops, the highest-ranking official representing the department's position at those meetings was Toscas. Asked whether she was informed of these concerns, Yates told the OIG that she was not. She said that she was not aware that McCabe attended meetings with the mid-year prosecutors, nor did she know that Comey was closely involved in the investigation. Yates stated that she spoke to McCabe regularly about various issues, and that she thought he was relaxed enough with her to tell her that she needed to be at any meetings. Yates said that any disparity resulted from the unusually high level of involvement by FBI leadership, not a decreased role by department leadership. Axelrod similarly told the OIG that at the outset of the mid-year investigation, senior department officials made efforts to set up a structure that would maintain the integrity of this matter. He explained that they were aware that no matter how the investigation turned out, there was likely to be criticism at the end. As a result, he said that they considered it extra important to make sure things were done by the book, following procedures. Making sure that when people criticized whatever the outcome was that we'd be able to say no, this was done straight down the middle on the facts and on the law. Axelrod said that he met with Toscas at the outset of the investigation and explained that Toscas would be the primary supervisor over the investigation. Axelrod stated, we were going to have sort of a lighter touch from the leadership offices than we might on a sort of high-profile case. In other words, we were there for him for whatever he needed. But we weren't going to be sort of checking in day to day or week to week for updates or briefings. When something significant happened, that we needed to know about, he would let us know. And when I say a lighter touch, I don't mean that folks weren't engaged or paying attention. Not at all. I just mean we wanted to give them the space they needed to do whatever they thought necessary in the investigation. So that at the end, I just wanted to make sure that any allegation that there was some sort of political interference with this investigation wouldn't hold water. Axelrod told the OIG that the difference between the role of department leadership in the mid-year investigation and the typical high-profile investigation was just a matter of degree. He said that he and Yates relied on Toscas to bring issues to their attention at skinny down sessions following the bi-weekly meetings with NSD, but that it wasn't us saying okay, and what's the latest on the email investigation. 54 Carlin told the OIG that NSD's standard practice is for cases to be handled by the career staff, supervised by a dog. He said that at the beginning of the mid-year investigation, he held a meeting with McCord, Toscas, and the NSD prosecutors in which he emphasized the need to go more by the book and to follow the normal procedure. Carlin said that he wanted one person in the NSD front office to be in charge of the mid-year investigation, and that he chose Toscas based on his historical expertise with investigations involving espionage, the straight-up spy cases, and the leak mishandling type portfolio. Carlin said that he preferred having one person who was clearly accountable and in charge. He stated, "I tend to like that as former career person, I knew what it felt like when you're in one of those spots. So, in general, I prefer that type of structure." In this case, I knew, as well, at the end of the day, whatever decision was made in the case, it was going to be a high-profile controversial decision. And so, you might need to explain later what process do we follow at the department. And so, I wanted to make that clear, internally and to our partners, that this was the process we were following, at the National Security Division. And just, seeing some other cases in my career that they were high profile. They were handled in a way that was different than the norm. More people got involved in trying to make the day-to-day decisions. I didn't think that redounded to the benefit of the case. Not just for appearance purposes, but it also just created confusion and frustration among the relevant teams. And kind of inconsistencies in how they were staffed, sometimes, when someone had a great idea later, and came in over the top, and changed the way they were approaching the case. So, right from the beginning, I wanted to set it up, and structure it that way. I felt pretty strongly about it. Carlin said that he discussed this with Lynch and Yates and made it clear to them that the team had the authority to make investigative and prosecutorial decisions. Carlin said that he told Lynch and Yates that, like other sensitive matters, we would periodically update them. According to Carlin, Lynch and Yates knew that this was how Carlin was handling the investigation and supported this structure. Carlin said that he also explicitly communicated this to the FBI, explaining it to both Giacalone and McCabe. For investigative strategy, the mid-year team sought to determine whether any individuals were criminally liable under the laws prohibiting the mishandling of classified information, which are summarized in Chapter 2. To do so, the team employed an investigative strategy that included 3 primary lines of inquiry: collection and 55 examination of the emails that traversed former Secretary Clinton's servers and other relevant evidence, interviews of relevant witnesses, and analysis of whether classified information was compromised by hostile cyber intrusions. 55 collection and examination of emails that traversed Clinton's servers and other relevant evidence. The mid-year team sought to collect and review any emails that traversed Clinton's servers during her tenure as Secretary of State, as well as other evidence that would be helpful to understand classified information contained in those emails. This included a review of the 30,490 work-related emails and attachments to those emails that former Secretary Clinton's attorneys had produced to the State Department. The team also attempted to recover or reconstruct the remaining 31,830 emails that Clinton's attorneys determined were personal and did not produce to the State Department. As described above and in Chapter 5, before the mid-year investigation began, these emails had been deleted and wiped from former Secretary Clinton's then-current server. The mid-year team also believed that some work-related emails could have been deleted from Clinton's servers before her attorneys reviewed them for production to the State Department. The mid-year investigators sought to recover and review deleted emails by obtaining and forensically analyzing, among other things, Clinton's servers and related equipment, other devices used by Clinton, such as Blackberries and cellular telephones, laptops and other devices that had been used to back up Clinton's emails from the server, and the laptops used by Clinton's attorneys to cull her personal emails from her work-related emails. The team also obtained email content or other information from the official government or private email accounts of certain individuals who communicated with Clinton by email, originated the classified email chains that were ultimately forwarded to Clinton, or transferred Clinton's emails to other locations. As described in Chapter 5, the mid-year team did not seek to obtain every device or the contents of every email account that it had reason to believe a classified email traversed. Rather, the team focused the investigation on obtaining Clinton's servers and devices. Witnesses stated that, due to what they perceived to be systemic problems with handling classified information at the State Department, to expand the investigation beyond former Secretary Clinton's server systems and devices would have prolonged the investigation for years. They further stated that the State Department was the more appropriate agency to remediate classified spills by its own employees. Analysts examined both the original 30,490 emails produced by former Secretary Clinton to the State Department and the emails recovered through Other 55. This section does not contain an exhaustive list of investigative efforts in the mid-year investigation, but rather is intended to be an overview of the mid-year team's investigative strategy. We discuss the specific investigative steps used during the mid-year investigation in Chapter 5. 56 means to identify potentially classified information. Once the analysts identified information that they suspected to be classified, the team sought formal classification review from government agencies with equities in the information. The analysts also examined the emails for evidence of criminal intent. For example, they searched for classification markings to assess whether participants in classified email chains were on notice that the information contained in them was classified, statements by former Secretary Clinton or others indicating whether Clinton used private servers for the purpose of evading laws regarding the proper handling of federal records or classified information, statements by former Secretary Clinton or others indicating whether they knew that emails contained information that was classified even if they were not clearly marked when they sent or received them on unauthorized systems, evidence as to whether former Secretary Clinton or others forwarded classified information to persons without proper clearances or without the need to know about it, and documentation showing whether originators of classified emails had received classified information in properly marked documents before transferring the information to unclassified systems without markings. Witness interviews. The mid-year team told us that witness interviews covered several areas of investigative interest. First, the team interviewed individuals involved with setting up and administering former Secretary Clinton's servers to understand her intent in using private servers and to assess what measures they used to protect the servers from intrusion. These witnesses also helped FBI analysts understand the server structures to inform subsequent analyses. Additionally, they helped FBI investigators identify additional sources of evidence, such as devices containing backups of Clinton's emails. Second, the mid-year team interviewed individuals who introduced, transmitted, or received information on unauthorized systems, including the originators of classified information, Clinton's aides who forwarded the originators' emails to her, and Clinton herself. The originators included State Department employees and employees of other government agencies. The team interviewed these witnesses to, among other things, assess 1. Whether they believed the information contained in the emails was classified, 2. How or from where they originally received the classified information, and whether based on those circumstances they should have known that the information contained in the emails was classified, and 3. Why they sent the information on unclassified systems. Third, the mid-year team interviewed individuals with knowledge of how and why 31,830 of former Secretary Clinton's emails were deleted from her servers and 57 other locations. The team sought to assess whether Clinton or her attorneys deleted or directed the deletion of emails for an improper purpose, such as to avoid FOIA or Federal Records Act (FRA) requirements. Fourth, the mid-year team interviewed State Department employees with knowledge of the State Department's policies and practices regarding federal records retention. The team sought to determine whether Clinton's use of a private server was sanctioned by the State Department, as well as what measures the State Department put in place to protect Clinton's private server from intrusion. See intrusion analysis. The FBI also conducted intrusion analyses to determine whether any classified information had been compromised by domestic hostile actors or foreign adversaries. Agents and analysts specializing in forensics examined the servers, devices, and other evidence to assess whether unauthorized actors had attempted to log into, scan, or otherwise gain access to the email accounts on the servers and, if so, whether their efforts had been successful. They also examined various FBI datasets to assess whether emails containing classified information had been compromised. 58 page left intentionally blank. 59 Chapter 4, Decision to publicly acknowledge the mid-year investigation and reaction to White House statements about the investigation. In this chapter, we address the decision of the FBI and the Department to publicly acknowledge an investigation following the public referral from ICIG, including the allegation that former Lynch instructed former Director Comey to refer to the mid-year investigation as a matter. We also discuss public statements by former President Barack Obama about the mid-year investigation, which raised concerns about White House influence on the investigation. As we describe in Chapter 6, Comey cited the events set forth in this chapter as two of the factors that influenced his decision to deliver a public statement announcing the closing of the mid-year investigation on July 5, 2016, without coordinating with the department. I. Public acknowledgement of the investigation. A. Statements about the investigation in Department and FBI letters to Congress in August and September 2015 following the public referral to the FBI from the ICIG in July 2015. The Department and the FBI received questions from the media and Congress asking whether they had opened a criminal investigation of former Secretary Clinton. According to emails exchanged in late August 2015, there was a significant disagreement between ODAG and FBI officials regarding whether to acknowledge that a criminal investigation had been opened. FBI officials, according to the emails, wanted to acknowledge opening an investigation into the matter, while ODAG officials approved language neither confirming nor denying the existence of any ongoing investigation, based on long-standing department policy. FBI and department letters sent to Congress on August 27 and September 22, 2015, and a letter sent by the FBI General Counsel to the State Department on September 22, 2015, used the neither confirm nor deny language. Contemporaneous emails show that former Director Comey disagreed with this approach. In an August 27, 2015 email to Deputy Director, D.D. Giuliano, Chief of Staff James Rybicki, and FBI Office of Public Affairs, OPA, Assistant Director, AD, Mike Cordon, he stated, "I'm thinking it a bit silly to say we can't confirm or deny an investigation when there are public statements by former Secretary Clinton and others about the production of materials to us. I would rather be in a place where we say we don't comment on our investigations." Rybicki told the OIG that Comey thought that the department and FBI needed to say more about the investigation because the ICIG referral was made publicly, and refusing to acknowledge an investigation would stretch any credibility the department has. 60B September 28, 2015 meeting between Attorney General Lynch and Director Comey in late September and early October 2015, Comey and Lynch each had upcoming media and congressional appearances. Anticipating that they would be asked whether the department and FBI had opened an investigation into former Secretary Clinton, Comey asked to meet with Lynch to coordinate what they would say. Comey told the OIG that it was the first time the two of them would be asked questions about the investigation publicly, and he wanted to discuss how they should talk about it given that there had been news coverage of the referral and a lot of public discussion about that the FBI is already looking into this. The meeting was held on September 28, 2015, and lasted approximately 15 minutes. Participants in the meeting included Lynch, Axelrod, and Toscas from the department, and Comey, Rybicki, and then D.D. Giuliano from the FBI. One Comey's account of the meeting: Comey told the OIG that during this meeting AG Lynch agreed they needed to confirm the existence of the investigation, but she said not to use the word investigation, and instead to call it a matter. Comey said that Lynch seemed slightly irritated at him when she said this, and that he took it as a direction. Comey stated, "And I remember saying, well, what should I call it? And she said, call it a matter. And I said, why would I do that? And she said, I just want you to do that, and so I would very much appreciate it if you would not refer to it as an investigation. And the reason that gave me pause is, it was during a period of time which lasted, where I knew from the open source that the Clinton campaign was keen not to use the word investigation. And so that one concerned me, and I remember getting a lump in my stomach and deciding at that moment should I fight on this or not." Comey told the OIG that he decided not to fight this instruction from the AG, but that it made his spider sense tingle and caused him to worry, that she's carrying water for the Clinton campaign. As described in Chapter 6, Comey told the OIG and testified before Congress that this instruction from Lynch was one of the factors that influenced his unilateral decision to make a public statement on July 5, 2016, without coordinating with the department. 56 However, Comey also said to us that he had no other reason to question Lynch's motives at that time, stating, In fact my experience with her has always been very good and independent, and she always struck me as an independent-minded person. 56 See U.S. Senate, Select Committee on Intelligence, Open Hearing with former FBI Director James Comey, 115th CONG, First Sess, June 8, 2017, https://www.intelligence.senate.gov/hearings/open hearing Former FBI Director James Comey Number, accessed May 8, 2018. 61 Comey stated that one of the reasons he remembered this meeting so well was that Toscas made a comment after the meeting about the Federal Bureau of Matters, indicating to Comey that Toscas had the same reaction I did to it. He said that Toscas did not say explicitly that he shared Comey's concerns about the meeting, but was signaling agreement to him through body language and humor. Rybicki and Giuliano did not specifically recall the discussion that took place at the meeting, other than that AG Lynch told Comey to refer to the investigation as a matter. Giuliano stated, I don't remember that specific meeting. I do remember the topic. And I do remember thinking that, A, it's ridiculous, and, B, quite honestly, I didn't care what they called it. It wasn't going to change what we did. He recalled discussions with the mid-year team after the meeting with Lynch, telling the OIG that a lot of people got wrapped around the axle about the issue and thought that that was kind of getting into the politics of the investigation. He also stated that Comey was definitely troubled by it. However, Rybicki said that he did not recall Comey being troubled by the meeting or expressing concern that the instruction from Lynch was an effort to coordinate with the Clinton campaign. Rybicki also said that he personally did not come away from the meeting with the view that Lynch was biased. Rybicki did recall Toscas joking about the Federal Bureau of Matters. To Lynch's recollection of the meeting, Lynch told the OIG that Comey expressed concern during the meeting about how to comply with the department's long-standing policy of neither confirming nor denying ongoing criminal investigations in the face of direct questions about the number of agents assigned to the case and the resources dedicated to it, because answering those questions implicitly would acknowledge that there was an open investigation. Lynch said that providing testimony about the allocation of resources or the way that the department works a case is a normal practice, but that in her view, they were not ready to publicly confirm an investigation. Lynch stated that her discussion with Comey was framed in terms of how they could testify about the resources dedicated to the investigation without breaking department policy. Lynch said that Comey was seeking guidance on how to handle those issues, particularly given that the referral was public, and that detailed information about the investigation had been discussed in the press. Lynch said that she was aware of numerous letters from members of Congress requesting information about the investigation, and that her meeting with Comey took place around the same time as a telephone call she had with Senator Charles Grassley, who wanted to discuss the department's handling of Brian Pugliano, a State Department employee who set up one of Clinton's servers, in '62 order to inform Congress's decision as to whether to grant him immunity to compel his testimony before Congress. 57. Lynch told the OIG, Senator Grassley was asking me literally, will I confirm that there is a criminal investigation of Secretary Clinton? Who are the other targets? Who are the subjects? Has a grand jury been impaneled? Has this young man Pugliano been given immunity? Would I give him a copy of the immunity order, and all the things that oversight typically asks for? So I knew, and I certainly had the view, that we had to be clear and open with oversight. You know, whether it's me or the director. But consistent with our law enforcement obligations, there are some doors that we do not open. And I did not think that we were ready to open that door on the Hill at that time. Lynch said that her concerns about opening the door to detailed questions about the investigation informed her view that the department should not confirm that there was an investigation. She said that she recalled stating at the meeting with Comey, "They don't need us to tell them that there is an investigation. They need us to confirm that there is an investigation. And there is a difference." She explained, and once we confirm it publicly, either by saying yes there is an investigation, or by talking about it in a way that confirms it, the next series of questions is going to be, is it criminal? And it's all going to be about, is the secretary a subject or a target? And there were others involved as well. There are other people beyond her who may or may not be named, but, you know, you start having these discussions. When will it be over? What are you finding? All those things that in fact Grassley did ask. The OIG asked Lynch if she instructed or told Comey, "I want you to call it a matter." Lynch said that she did not and would not have, because that was not how she spoke to people. She told the OIG that she remembered saying the following at the meeting, "Well, I do remember saying, you know, we typically say we have enough resources to handle the matter. I don't know if I used other words like the case, you know, the inquiry, or something like that. But I do remember saying that, and I think I may have been saying that because, again, I was always careful not to talk about an investigation." 57. Based on notes and department emails, the OIG determined that Lynch's call with Senator Grassley was scheduled for later that same day, September 28, 2015. According to talking points prepared for this call, Lynch intended to tell Senator Grassley that the department could neither confirm nor deny the existence of any ongoing investigation or persons or entities under investigation, consistent with long-standing department policy. The talking points stated, "This policy, which has been applied across administrations, is designed to protect the integrity of our investigations and to avoid any appearance of political influence." 63. I was getting questioned about the referral, and is it going to lead to an investigation, and, you know, we have it, we acknowledge it, we're going to handle it. And that's all I can say, kind of thing. And so I know that in addition to saying, yes, everyone knows there's an investigation. They don't need us to tell them that. They need us to confirm it, and we don't do that. And here's why we don't do that. I remember making those statements. And I remember saying, but of course you've got to respond. And one way to respond is just to say, you've got what you need to handle the matter. Lynch said that she thought that there had been agreement at the meeting about what to say. Her takeaway was that they were going to take steps not to confirm that there was an official investigation open and would be careful not to do so in how they discussed it. Lynch stated, "It wasn't a long meeting. It was that, it wasn't contentious. Nobody seemed upset. So it was more of a discussion." She said that she did not recall Comey or anyone else expressing disagreement, or Comey asking, "Why on earth would I do that?" Lynch said that the decision to avoid confirming an investigation was not made with any political motive in mind, and that she did not coordinate messaging with the Clinton campaign. Lynch told the OIG that she was surprised to learn from Comey's later congressional testimony that he interpreted the discussion at this meeting as evidence of potential political bias. She stated, "I was surprised. I was disappointed, somewhat angry. And mostly surprised that he had never raised it either at the time or later, that if it was a concern I was surprised that if he thought that it was a problem, he was okay also handling things in that way. I just had never viewed him as someone who was reluctant to raise issues or concerns, given that I had known him for some time." Lynch recalled Toscas making a joke about the Federal Bureau of Matters to one of the agents who was sitting beside him, and people laughing. She said that she took this as a joke, as good-natured ribbing or teasing, and that the laughter told her that others in attendance also took it as a joke. Axelrod told us that the discussion about whether to acknowledge an investigation was just one small part of that meeting. He said that Lynch suggested using the term matter as a way of threading the needle to avoid violating department policy while also not appearing evasive. According to Axelrod, no one from the FBI raised objections during the meeting, and the tone of the discussion was collegial. He said that he thought that Comey and Lynch had reached a mutual agreement that using the term matter was the best way to thread the needle. Axelrod told the OIG that he was surprised to hear Comey's later congressional testimony that he, Comey, felt uncomfortable with the discussion, which Axelrod said was not consistent with his recollection of Comey's reaction in the room, and did not square with his recollection of the facts. 64-3. Toscas's notes and recollection of the meeting. Toscas took detailed notes at the September 28 meeting, which he provided to the OIG. Toscas said that his notes were unusually lengthy for such a brief meeting because AAG Carlin was out of town and he was asked to attend in Carlin's place, and he wanted to be able to tell Carlin what happened. Referencing his notes, Toscas testified to the OIG at length about what took place during the meeting. According to Toscas, Comey told Lynch that he planned to acknowledge at a House Permanent Select Committee on Intelligence, HPSI, roundtable that the FBI had received the referral from the ICIG and that it was being properly staffed and receiving all necessary resources. Comey stated that he planned to say that the FBI does not comment on its investigations per long-standing policy, but that all of its investigations are done professionally and timely. Toscas said that Comey assured Lynch that he would not say that they had opened an investigation, but that this would be implicit in what he said, and there would be news reports afterwards saying that there was an investigation. According to Toscas, Lynch replied that she preferred to discuss it in terms of a matter. "His is the way I do it, and then it avoids this issue because we should neither confirm nor deny." Toscas said that he interpreted Lynch's statement as expressing her preference rather than telling Comey what he should do. Toscas stated he did not recall Lynch instructing Comey to call it a matter, and he thought he would have remembered that if it had occurred. He also said that he did not interpret Lynch's comment as her trying to shade the investigation into something it wasn't for some particular reason. However, he acknowledged that he was not the FBI director, and that Comey may have had a different perspective. Toscas said that after Lynch's comment, Axelrod stated that they needed to coordinate what to say with a letter sent by the FBI General Counsel to the State Department the previous week and attached to a public filing in FOIA litigation, in which the FBI took great pains to not call this an investigation, so as not to confirm the existence of an investigation. According to Toscas, the department and the FBI had used the same language in other letters to Congress, and Lynch had a call scheduled later that day with Senator Charles Grassley in which she planned to tell him that it would be premature to acknowledge or share information about any investigation. Toscas said that Axelrod's statement led to a back and forth between Comey and Axelrod, during which Comey proposed modifying the letters to Congress to acknowledge that the FBI had opened an investigation. Toscas said that he was not sure if Comey was toying with Axelrod at that point because I don't think we would ever reissue letters that clearly state normal positions. Toscas said that Comey then asked Axelrod directly, "Why not use the word, you know we're trying to treat it like any other case and would we do that ordinarily?" In response, Axelrod again mentioned the need to be consistent with the letters that were sent the previous week. 65 Toscas told the OIG that he mentioned at the meeting that the department opens only a small fraction of the referrals it receives from the intelligence community as criminal investigations, and that the department may not want to publicly acknowledge an investigation into former Secretary Clinton because it could serve as precedent for other referrals. Toscas said he also made clear to the group that mid-year was a criminal investigation, and that the prosecutors had referred to it as an investigation in letters to counsel and in search warrant applications. Toscas said that Comey concluded the meeting by agreeing to call it a matter, stating, "Okay, I think that will work." This statement also appeared in Toscas's contemporaneous notes. Toscas told the OIG that there was no indication at the time that Comey was concerned about the meeting or that the meeting had led him to question Lynch's impartiality. Asked whether he made a comment to Comey about the Federal Bureau of Matters, Toscas said that he did not specifically recall doing so but may have. He said that, if he did, he intended it as a joke rather than as a criticism of Lynch. He told the OIG, "I don't know if I ribbed Comey walking out. You know he's a friend of mine. In any event, maybe I said that, maybe I didn't. It wouldn't faze me if I did, because it was in line with what I was saying to them about investigation being part of the FBI's name. But it makes it appear as though I was sort of knocking the AG Lynch in the way they reported it, which is obviously why some goofball felt that they should talk about that to the newspapers." 58C October 1, 2015 Comey meeting with media in a pen and pad with reporters on October 1, 2015, Comey used the term matter in response to questions about whether the FBI had opened an investigation. According to a transcript of the appearance, Comey told reporters that he recently had a closed session with HPSI and would say publicly what he told the committee, that the FBI had received a referral involving former Secretary Clinton's use of a private email account and the possible exposure of classified information through that account, but that he was limited in what he could say because the FBI does not talk about its ongoing work. Comey stated, "I am following this very closely and I get briefed on it regularly. I am confident that we have the resources and the personnel assigned to the matter. As we do all our work, so we're able to do it as we do all our work in a professional, prompt, and independent way." Asked about the timeline for completing any investigation, Comey stated, "Again, I'm not going to talk about this particular matter. Part of doing our work well is we don't talk about it while we do it." 58C Matt Apuzzo etal, in trying to avoid politics, Comey shaped an election, NY Times, April 23, 2017, at A1, referencing two sources who reportedly heard Toscas state, "I guess you're the Federal Bureau of Matters now." 66 Following Comey's appearance, various news articles reported that Comey had acknowledged the existence of an investigation into former Secretary Clinton's use of a private email server. 59 Comey received an email containing news clips summarizing several of these articles and forwarded it to Rybicki, stating, "We'll leave it to you to tell DOJ that I never used the word investigation." Rybicki replied, "Already covered. I read back your statement to them and told them this is exactly the type of confusion we were concerned about as we were crafting." 2. Reaction to White House statements about the mid-year investigation. On Sunday, October 11, 2015, an interview of then-President Barack Obama was aired on the CBS show 60 Minutes. During this interview, Obama characterized former Secretary Clinton's use of a private email server as a mistake, but stated that it did not pose a national security problem and was not a situation in which America's national security was endangered. Obama also stated that the issue had been ginned up because of the presidential race. 2 days later, on October 13, 2015, Obama's press secretary, Josh Earnest, was asked whether Obama's comments should be read as an attempt to steer the direction of the FBI investigation. Earnest replied that Obama made his comments based on public information, and they were not intended to influence an independent investigation. Former President Obama's comments caused concern among FBI officials about the potential impact on the investigation. Former EAD John Giacalone told the OIG, "We open up criminal investigations. And you have the President of the United States saying this is just a mistake. That's a problem, right? Former AD Randy Coleman expressed the same concern, stating, "The FBI had a group of guys in here, professionals, that are conducting an investigation. And the President of the United States just came out and said there's no there." Coleman said that he would have expected someone in FBI or department leadership to contact one of Obama's national security officials, and tell him or her, "Hey, knock it off." Michael Steinbach, the former EAD for the National Security Branch, told the OIG that the comments generated controversy within the FBI. Steinbach stated, "Why are you prejudging the results of an investigation before they really even have been started? That's hugely problematic for us." Department prosecutors also were concerned. Responding to an email from Loffman about Obama's 60 Minutes interview, Tosca stated, "Saw this. And as one of the prosecutors and I discussed last week, of course it had no and will never have any effect whatsoever on our work and our independent judgment." Prosecutor 4 told the OIG that Obama's statement was the genesis of the FBI's suspicions that the department's leadership was politically biased. This prosecutor stated, "I know that the FBI considered those statements inappropriate. And that it generated a suspicion that there was a political bias going on from the executive branch." 59C, e.g., Pete Williams, FBI director acknowledges agency looking into Clinton emails. NBC News, October 1, 2015, http://nbcnews.to/1lmhum, accessed January 18, 2018. 67 Asked about former President Obama's statements, Lynch stated, "I never spoke to the president directly about it, because I never spoke to him about any case or investigation. He didn't speak to me about it either." She told the OIG that she did not think the president should have made the comment on 60 Minutes. She stated, "I don't know where it came from. And I don't know why he would have thought that either, to be honest with you. Because, to me, anyone looking at this case would have seen a national security component to it. So I truly do not know where he got that from." Former President Obama's press secretary, Josh Earnest, made additional comments about the mid-year investigation during a press conference in early 2016. On January 29, 2016, in response to a question about whether the White House thought that former Secretary Clinton would be indicted, Earnest stated, "That will be a decision that is made by the Department of Justice and prosecutors over there. What I know that some officials over there have said is that she is not a target of the investigation. So that does not seem to be the direction that it's trending, but I'm certainly not going to weigh in on a decision or in that process in any way. That is a decision to be made solely by independent prosecutors. But, again, based on what we know from the Department of Justice, it does not seem to be headed in that direction." After this press conference, Melanie Newman, the director of the department's Office of Public Affairs, OPA, received a transcript of Earnest's statements about the investigation and forwarded it to Axelrod and 3 other department officials. Newman stated in the email to these officials, "I've spoken to the White House and asked that they clarify this, to make clear they have no insight into this investigation. And if they don't correct it, I will. I'm waiting to hear back." This email also was forwarded to Lynch. Asked about this email, Newman said that she spoke to Earnest that day. Newman said that Earnest told her that he had based his comments on what he had read in news stories, not conversations with anyone in the department. She said that no one in the White House ever reached out to her about the mid-year investigation, nor was she aware of White House staff reaching out to anyone else in the department, noting, "They were very, very, very careful about engaging with us on that topic." Axelrod similarly told the OIG that Earnest's comments implied that the White House had received a briefing on the mid-year investigation, which he said never happened. Lynch's chief of staff stated that department officials were very upset about Earnest's statement, because as far as we knew, no one at Department of Justice had spoken to anyone in the White House about it. The Chief of Staff told the OIG that they were particularly concerned by Innest's statement that former Secretary Clinton was not a target. The Chief of Staff said that she spoke to officials in the White House counsel's office to tell them that the department did not know where Ernest was getting his information, and to ask them to talk to Ernest. The Chief of Staff did not specifically recall Lynch's reaction to this 68 statement, but said that she was probably very upset. Anytime there was ever any suggestion that the White House, or that DOJ had improperly done something in an investigation, or discussed something of a political nature, she would not be happy about it. Prosecutors again were concerned by these comments. On January 29, 2016, Tosca sent the following email to Loffman, seeking to assure the team that the investigation would not be influenced by White House statements. As discussed, I spoke with ODAG and they are not aware of anybody from DOJ sharing any such information or assessment with the White House, as the below statements appear to suggest. I want to reiterate what I've told you and the team throughout our work on this investigation. The explicit direction we received from the AG and DAG on multiple occasions is that they have total confidence in the team of prosecutors who are working on this case, and they have instructed us to proceed with this matter as we would any other, without interference of any kind, and with the independence we have in all of our cases. They have never wavered from that and have never said or done anything to send or suggest a contrary message. With respect to the below statements that erroneously imply that the department has shared information about, or an assessment of, this matter with the White House, we should not and will not allow such irresponsible statements to have any effect at all on our work. We will continue to thoroughly and professionally investigate this matter as we would any other, and, as always and as you, John Carlin, and I have said repeatedly, we will follow the facts wherever they lead. Thanks. Toscas emailed Loffman a second time, stating, "Please feel free to share this with the whole team, if you haven't already." During his interview with the OIG, Toscas described Innest's statements as goofy and ridiculous, expressing frustration that he had to address comments by the White House when preparing Lynch to testify before Congress because of the perception of political bias that they created. Asked about Innest's statements, prosecutors told the OIG that the only interactions they had with the White House concerning the investigation were with the White House counsel's office to obtain a classification review of documents in a Special Access Program, SAP, controlled by the White House, and to interview a National Security Council staffer. Prosecutor 1 told the OIG that he was not aware of contacts between department leadership and the White House counsel's office or White House staff. Notes taken by Loffman indicate that on January 30, 2016, one of the prosecutors reached out to their point of contact in the White House counsel's office and asked about Innest's comments. According to these notes, this prosecutor was told that the content of the discussions between the White House counsel's office and the mid-year team about the classification review and the interview of the staffer was limited to a small group of people in the White House counsel's office, and that nothing that the prosecutors had discussed with the White House counsel's office would be known to Ernest. 69 Lynch testified before the Senate Judiciary Committee on March 9, 2016. Asked about the investigation, Lynch stated that she had never discussed the investigation with former President Obama or anyone in the White House. Lynch stated, "It's my hope that when it comes to ongoing investigations that we all would stay silent. And I can assure you that neither I nor anyone from the department has briefed to Mr. Ernest or anyone at the White House about this matter or other law enforcement matters. I'm simply not aware of the source of his information." 60 Lynch told the OIG that she recalled that Newman spoke with the White House Communications Office after Innest's comments and was clear that they were inappropriate and needed to be corrected. Asked whether she perceived these comments as an effort to direct where the investigation was going or felt influenced by them, she said that she did not. Lynch said that she also had a discussion with the White House counsel after she testified, and that during this discussion he acknowledged that the comments should not have happened. However, former President Obama again made public comments about the mid-year investigation in an interview with Fox News Sunday on April 10, 2016. Obama stated that while former Secretary Clinton had been careless in managing her emails while she was Secretary of State, she would never intentionally do anything to endanger the security of the United States with her emails. He also stated that he would not interfere in the FBI's investigation into her private email server. Obama stated, "I guarantee that there is no political influence in any investigation conducted by the Justice Department, or the FBI, not just in this case, but in any case." 6160 U.S. Senate, Committee on the Judiciary, Oversight of the U.S. Department of Justice, 114th Cong, 2D Sess, March 9, 2016, https://www.judiciary.senate.gov/meetings/oversight of the U.S. Department of Justice. 61C Transcript, President Barack Obama on Fox News Sunday, April 10, 2016, at http://www.foxnews.com/transcript/201604/10/exclusive-president-barack-obama-on-fox-news-sunday.html, accessed March 22, 2018. 70-page left intentionally blank. 71 Chapter 5, Investigative Methods used in the investigation. The mid-year team used several types of investigative methods and made various strategic decisions during the course of its investigation. Some of these decisions have been the subject of criticism and allegations that they were based on improper considerations. In this chapter, we describe the following investigative methods and decisions made by the mid-year team: efforts to identify relevant sources of physical evidence, efforts to understand and access Clinton's servers, use of criminal process, including subpoenas, 2703(d), orders, and search warrants to obtain physical evidence, use of consent to obtain physical evidence, efforts to obtain evidence related to Clinton's senior aides, use of voluntary interviews, decisions to grant certain witnesses, use immunity, strategies employed to secure voluntary interviews and voluntary production of evidence from Cheryl Mills and Heather Samuelson, and investigative decisions surrounding the voluntary interview of Hillary Clinton. We describe the reasons given for these decisions, disagreements among members of the mid-year team about them, especially between the FBI and the prosecutors, and the impact of these decisions on the investigation's access to relevant information and the completeness of the investigation. We also describe an internal file review of the mid-year investigation conducted by the FBI's Inspection Division, INSD, in September and October 2017 following our discovery of concerning text messages between Strzok and Page. In addition, we discuss instant messages in which Agent 1 expressed concerns about the quality of the mid-year investigation. We considered these messages as part of our analysis of whether the mid-year team conducted a thorough and impartial investigation. In the analysis section of this chapter, we assess whether the evidence supports a conclusion that any of the investigative decisions we reviewed were based on improper considerations, consistent with the analytical construct described in Chapter 1. FBI's efforts to identify and review relevant sources of evidence. The mid-year team began its investigation by reviewing the 30,490 emails that Clinton had produced to the State Department. They reviewed them to identify emails that appeared to contain classified information and evidence of intent to mishandle classified information. 62 Witnesses told us that to search for evidence of intent, the analysts looked for, among other things, classification markings on the documents, statements indicating that email participants knew. 62 The mid-year supervisory special agent told us that the State Department provided these emails to the FBI in paper form. According to the LHM, on August 6, 2015, Clinton's attorneys voluntarily provided the FBI thumb drives containing the same emails. 72 Information was classified, and statements indicating that Clinton decided to use a private server for an improper purpose, such as to avoid FOIA or other laws. One analyst told us that there were at least 6 analysts consistently involved with reviewing these emails, and, at times, there were as many as 15 or 16 analysts doing so. Once the team identified emails that appeared to contain classified information, they sent them to other agencies within the U.S. intelligence community, USIC agencies, with equities in them for formal classification review. FBI agents and department prosecutors told us that, Thereafter, a large focus of the investigation was locating the remaining 31,830 emails that made up the entire 62,320 emails that Clinton's attorneys had reportedly reviewed before producing her work-related emails to the State Department. Clinton's attorneys did not produce those 31,830 emails to the State Department because, they stated, they were personal in nature. Instead, the attorneys instructed Paul Cometa of Platte River Networks, PRN, the company that managed Clinton's server, to remove the emails from their own laptops and modify the server's email retention period so that emails older than 60 days would not be retained. In March 2015, Cometa removed the emails from Clinton's server using BleachBit after realizing he had failed to implement the new email retention period several months earlier. The FBI team wanted to review these emails, if possible, to determine whether any were work-related or contained classified information, and to search for evidence of Clinton's intent in using a private server. FBI agents and analysts, including the Supervisory Special Agent, SSA, assigned to the mid-year investigation, told us that to find the missing 31,830 emails, the team attempted to identify and obtain access to any server or device, whether it was a BlackBerry, iPad, PC, or phone Clinton used during her tenure, as well as devices used to back up her emails. The FBI also sought email content or header information from the official U.S. government and private email accounts of certain individuals who were known to communicate directly with Clinton by email or who were involved in email chains that ultimately resulted in classified information being forwarded to Clinton. However, as discussed in Section VC of this chapter, the FBI did not seek to obtain the personal devices of State Department employees, besides Clinton, who sometimes used private email for State Department work and who used those devices to communicate with Clinton while she was Secretary of State. Based on our review, the FBI sent preservation requests to the State Department for nearly 1,000 official State Department email accounts. One analyst told us that the State Department was unable to supply many of the email records the FBI requested due to, among other things, limitations in the State Department's record-keeping systems. However, the FBI obtained records from the official State Department email accounts of certain employees, including the 3 senior aides with whom Clinton had the most email contact. The FBI also made requests of other government agencies, including the CIA, the Defense Intelligence Agency, DIA, the Department of Defense, DOD, and the Executive Office of the President, EOP, to search their official email systems for emails to or from email accounts on the clintonemail.com domain. In addition, as discussed in sections 373 and V below, the mid-year team used compulsory process to obtain email records from certain private email accounts. The FBI also requested the State Department issued computers and handheld devices used by certain employees during their State Department tenure. However, with the exception of a desktop computer used by Brian Pugliano, a State Department employee who set up Clinton's second server, the State Department told the FBI that it either did not preserve or could not locate those devices. FBI witnesses told us that both FBI agents and analysts were involved in determining what devices and other evidence to obtain. Based on our review of the evidence, the FBI obtained more than 30 devices, received consent to search Clinton-related communications on most of these devices, and identified numerous work-related emails that were not part of the 30,490 emails produced by Clinton's attorneys to the State Department, many of which they sent to other agencies for classification review. The 30 devices included 2 of Clinton's servers, each of which consisted of multiple devices, storage devices used alongside Clinton's servers, numerous devices that were used to back up Clinton's emails during her tenure, some of Clinton's handheld devices, Pugliano's State Department desktop computer, several flash drives and laptop computers that contained copies of the 30,490 emails that Clinton's attorneys produced to the State Department, and the 2 laptops used by Clinton's attorneys to cull her emails for production to the State Department. Once the FBI received consent to review a device, staff from the FBI's Operational Technology Division, OTD, generally imaged the device and prepared the image for a filter team to remove material that was privileged or otherwise not subject to search pursuant to the terms of a consent agreement. OTD then uploaded the emails and other data from the device for FBI analysts to review. OTD also attempted to deduplicate emails. The analysts reviewed the emails recovered from each device for the same purposes as they reviewed the initial 30,490 to identify both suspected classified information and evidence of intent to mishandle classified information. The mid-year team also sought and obtained a wide range of other information relevant to the investigation, such as Clinton's cable, telephone, and internet subscriber and service information, financial information for certain witnesses, business records pertaining to the services provided by the companies that supported Clinton's servers, records related to security services protecting Clinton's servers, and information from mail carriers related to the delivery of a laptop that at one time stored Clinton's archived emails. Prosecutor 1 told us that the team sought records from at least 3 different companies in an effort to find the BlackBerry emails from the beginning of Clinton's tenure as Secretary of State. 63 analysts told us that they reviewed these materials to search for, among 63 based on the LHM, the 30,490 emails provided by Clinton's attorneys to the State Department contained no emails sent or received by Clinton during the first 2 months of her tenure, January 21, 2009, through March 18, 2009. And the FBI investigative team was unable to locate the BlackBerry device she used during that time. Witnesses, including former Director Comey, told us 74 other things, evidence of mishandling classified information and additional leads for information. For example, one analyst stated that through records obtained from various phone companies, he was able to identify the 13 devices that were associated with 2 telephone numbers that Clinton used. According to the LHM, the FBI found and reviewed approximately 17,448 unique work-related and personal emails from Clinton's tenure containing her email address that were not part of the original 30,490 that Clinton's lawyers had produced to the State Department. Comey stated in his July 5, 2016, press conference that the FBI found several thousand work-related emails that were not part of the 30,490 emails. However, one analyst told us, and documentation we reviewed showed, that the FBI did not conduct its review in such a way that it could calculate the precise amount of work-related emails discovered by the FBI that had not been produced to the State Department. Instead, as described below, they focused on identifying the number of classified emails that both were and were not included in the 30,490. None of the emails, including those that were found to contain classified information, included a header or footer with classification markings. As we discuss further in Chapter 7, this absence of clear classification markings played a significant role in the decision by the mid-year prosecutors to recommend to Attorney General Lynch in July 2016 that the investigation should be closed without prosecution. According to the LHM, the FBI, with the assistance of other USIC agencies, identified 81 email chains containing approximately 193 individual emails that were classified from the confidential to top secret levels at the time the emails were drafted on unclassified systems and sent to or from Clinton's personal server. In other words, the USIC agencies determined that these 81 email chains, although not marked classified, contained information classified at the time the emails were sent and should have been so marked. 12 of the 81 classified email chains were not among the 30,490 that Clinton's lawyers had produced to the State Department, and these were all classified at the secret or confidential levels. 7 of the 81 email chains contained information associated with a Special Access Program, SAP, which witnesses told us is considered particularly sensitive. The emails containing top secret and SAP information were included in the 30,490 provided to the State Department. In June 2016, near the end of the investigation, investigators found 3 email chains, consisting of 8 individual emails, that contained at least one paragraph marked C, a marking ostensibly indicating the presence of information classified at the confidential level. According to a June 13, 2016 text message exchange between Strzok and Page, the emails containing the C portion markings were part of the 30,490 that Clinton's attorneys had provided to the State Department in 2014, but the FBI did not notice them until June 2016 after the ICIG discovered them. By that point in time, as discussed in Chapter 6 below, Comey had been drafting his statement announcing the closing of the investigation. Strzok that they believed these missing emails could contain important evidence regarding Clinton's intent in setting up a private email server. 75 wrote to Page that DOJ was very concerned about this. Because they're worried, holy cow, if the FBI missed this, what else was missed? Strzok further wrote, no one noticed. And while minor, it cuts against I never sent or received anything marked classified. 64 According to the prosecutors, Mills, Abedin, and Jake Sullivan were each parties to at least one email in the chains with the C markings. However, none of them were ever asked about the emails, because the FBI had not discovered the markings before their interviews and did not seek to re-interview them. 65 Witnesses told us that although the FBI found work-related emails, including classified emails, that were not part of the 30,490 produced to the State Department by Clinton's lawyers, they were not able to determine whether these emails were part of the original 62,320 reviewed by Clinton's attorneys. This is because some of the emails they found through other sources could have been deleted from Clinton's account or overwritten in the ordinary course before Clinton's attorneys reviewed her emails for production to the State Department. Thus, they also were unable to determine how many of the 31,830 deleted emails were never recovered. The FBI also conducted intrusion analyses on each of the devices and other evidence to determine whether any classified information had been compromised. An FBI agent assigned to the mid-year team to conduct intrusion and other forensic analysis, forensics agent, described the team's efforts in this regard as exhaustive. He stated that these efforts included 1. Examining the servers and others' devices to identify suspicious logins or other activity, and 2. Searching numerous datasets to determine whether foreign adversaries or known hostile domestic actors had accessed emails that the mid-year team had confirmed to contain classified information. Comey stated the following in his July 5, 2016, press conference regarding possible cyber intrusion of Clinton's email servers. With respect to potential computer intrusion by hostile actors, we did not find direct evidence that Secretary Clinton's personal email domain, in its various configurations since 2009, was successfully hacked. But, given the nature of the system and of the actors potentially involved,